wonderful host for today. It's Courtney Buchan from GRS Community Management. Courtney, please take it away.
Thank you so much, Jeff. So welcome everyone, board members, CAMs, to Kaye Rembaum's presentation on HOA board certification. This is a really important one. If you are a new board member, there's going to be a lot of important information discussed today by Alan Schwartzseid. I want to make sure I'm saying your name right. Schwartzseid. So I want to say, I think that you are one of the most popular presenters for Kaye Rembaum, and you will not be bored. He's very entertaining and thorough. He's going to go over a lot of things that pertain to board certification, being a board member, what your role is in the community. I'm a licensed CAM myself, and I'm also a board member. So I've sat through this class to get certified myself before. I know it's a long one, but it's so important to get that done and out of the way, and you'll learn a lot about your new role in your community. So I'm a licensed CAM, a board member, and I'm also the corporate trainer for GRS Community Management. We are a mid-sized management company based out of Lake Worth, Florida. We manage over 200 communities all across Florida. If you are a board member looking to make a change, please visit our website at grsmgt.com. If you're a CAM as well, and you don't currently work for GRS Community Management, we are always hiring. So again, grsmgt.com is our website. You can also find us on Facebook, LinkedIn, Instagram, and X, formerly known as Twitter. So with that being said, I want Alan to get into this because I know this is a very long one. So again, thank you everyone for coming. Thank you to Kaye Rembaum for providing this webinar, Alan for presenting this webinar, and Jeff for setting up this webinar. Thank you.
Well, that's a lot of thanks, and thanks from our end as well, Courtney. We appreciate you having us here today. I won't mention to my other partners that I'm the most important one out of the entire group when it comes to presentations. I'll just leave that one alone for now, but I appreciate it.
You're welcome.
So a little bit about our firm. Kaye Rembaum's been in the business of representing community associations and doing pretty much nothing else since the 1990s. That's all we do. So, we literally do everything start to finish, from the creation of a community association up through, frankly, termination, which is something we hope never becomes necessary, but is something that we do have some experience in dealing with. We have 21 attorneys, about to be 22 as of next Monday, because there will be another associate joining our Orlando office, which is the one I manage. We've also got offices in Pompano Beach, Palm Beach, and Tampa, and in Miami by appointment. 8 of our attorneys, and I believe it's now 9, are board certified in community association law, meaning the Florida bar recognizes their expertise. Another attorney out of the firm is also board certified in construction law. So when I say start to finish, we're not your door firm that takes everything that comes in the door. We're your community association only, very rarely ever represent individuals type of firm. So that's not to say don't reach out if you're an individual. I do have a lot of attorneys that we work with that I'd be happy to refer you to if it's not something we can help with. But bottom line, anything related to a community association, it's what we do. And along the same lines of what Courtney mentioned, if your community doesn't have counsel, which it surprises me to hear that those exist in Florida, or if you're not entirely enthused with your counsel, or frankly, you're just looking to see what else is out there, we don't require annual fees except for our specialized collection retainer program. We don't require monthly minimums. So a lot of the time we'll come in for an individual project, and frankly, the board is so thrilled with our performance in that respect, and especially my 24-hour turnaround time, which most of the attorneys in the firm will also follow, meaning you will get an acknowledgement or a substantive response within 24 hours or 1 business day after you write to us or call us. A lot of times after working with us for one project or a secondary, we end up shifting into that primary counsel role. So along with all of that, I welcome anyone that's on this meeting today or anyone that's viewing it at a later date. shoot me an email. My email address is about to be on the screen. I just realized I didn't share my screen yet. I think I did the same thing during our last board certification. And whoever's the host needs to allow that. So I'll start and kind of explain where we're at. But my email address is as@kbrlegal.com. And that's the easiest way to reach me at pretty much any time, anywhere, anyhow. So now I will go ahead and hopefully I'm sharing the correct screen at this point, and you can see, yep, looks like we're good to go. So we'll go
Looks
ahead and
good.
get started in earnest now. Jeff, thanks for your help. Moving forward, if the screen will move forward. All right, why are we here? Well, you're here because you have to be. And that's not currently a legally accurate statement, but it's about to be, and I'll explain that a little bit more. So as of now, you have two options of how you can become certified as a board member in a Florida Community Association, and in particular in an HOA, since that's what we're here to talk about. One is within 90 days after being elected or appointed to the board. The newly appointed directors can either take a class like this, get the certificate that Jeff mentioned at the end of the class, and provide that to your secretary or your manager. Or you can sign a document that's basically a lie. And what I mean by that is your alternative as of right now is to sign a certificate that basically says, I've read the governing documents of the community and I'll do my best to uphold what's in them. Now, the problem with that is that your governing documents are most likely written horribly. Keep in mind who drafted those. The developer drafted them to protect the developer. Okay, it's not their obligation to make sure that this community runs smoothly after they turn over. That's the board's obligation to make sure that any of those problems that were caused by the developer get fixed. And when I say that's the board's responsibility, understand, if you are a director of your community, that's you now. So if there are problems with what's in your governing documents, you're going to want to contact counsel. If you don't have counsel, you're not happy with them, contact me to potentially make those changes to make your governing documents, frankly, make sense. And that's the problem I have with this certificate. You say you're going to do your best to uphold what's in these documents, but in reality, you have no clue what the hell's in these governing documents because even I can't read them half the time. Because they're poorly written, they're vague, they conflict internally, they conflict with the Florida statutes and Florida case law. And that's even if you've already done some amendments to kind of clean them up. So our suggestion, and I know I'm preaching to the choir here, is attend a class like this. So you're already doing the right thing by being here. But the bottom line is you have those two options, either within the first 90 days after you're elected, or you can take this class up to a year in advance of being elected. Now, the certificate you're going to get is going to have to stay in the association's records for up to 5 years, or longer if you stay on the board longer. But it's at least 5 years that this is an official record of the association. Okay, I mentioned that there might be a little bit of a change and that as of now, you can choose either of these options. There is legislation that's being proposed at this point, which is one of the few good ones this year, that would actually require all community association directors to take both the certification class and sign the certificate, meaning you get the education and you don't have to worry about getting the certificate from the education provider potentially, but it's just going to depend on what the legislature decides to do. But you also sign the certificate, and there's also potentially an ongoing education requirement that'll kick in. Now, I mentioned elective classes. Those are all the classes except this one. As of right now, this is the only one that directors are required to attend. And frankly, it's not even required to have any education. I think that's a very dangerous proposition. But I will mention, we're teaching this class along with GRS, and we're happy to do it. We're proud to be part of their class today. We also offer a ton of other free education. I'll ignore the ones that might be with other management firms. Those are mostly going to be board certifications as well. But GRS hosts a bunch of these. They do a great job hosting. We also teach a lot of other classes that are an hour to 2 hours long that are not required. I'd suggest you check those out on our website at kbrlegal.com. If you go to the calendar, you'll see what's coming up this month and next month. We've got a ton of educational programs because, frankly, that's just really important to us to make sure that your board is doing things right so that we are making sure you do it right rather than fixing the problem later, which, generally speaking, just a heads up, is going to cost a lot more than getting the opinion in the first place and relying on that opinion. A director who doesn't do this, doesn't sign that certificate that's basically a lie, or take this class and get the certificate to the secretary or the manager, is technically suspended, meaning they're off the board until they take care of that requirement. Okay, all they have to do is sign the certificate and they're back on, or take this class and they're back on. Not a big deal, but just understand that is a way that I've seen people removed from the board. And if it takes them a week to get that done, they're off for a week. Now, the other thing to keep in mind is failure to have this certificate doesn't mean that anything that director did when they were supposed to have the certificate, let's say they wait 120 days instead of the 90 they're provided, anything that happens during that last 30-day period when they were technically in violation of this requirement is still going to exist. It's going to be fine. It's a kind of a no harm, no foul type of situation. So you're not going to undo every vote that was made by this individual, but just understand that they are doing it wrong, both in my opinion and under Florida law. Moving forward, and we will get into Q&A later if we have time. I'm sure we will have some time, but just understand if you got questions about anything that I say today, you're unclear on any of it, or frankly, if I stumble over my words and you say, what the hell did that guy just say? Which may happen towards the end because we're talking about 188 slides to get through today. Feel free to email me. Feel free to reach out to Courtney at GRS, and we'll get you your answers to the extent we possibly can. If it requires us to look at your governing documents, that may require a representation agreement first. All right, so moving on to Chapter 720, there's a lot in here. We talk about condos versus HOAs. I'm not going to go through it, but I did want to make sure, like Jeff might have mentioned earlier, you guys will get the materials at the end of the class. I wanted to make sure that this material was here because we've already prepared it, and I think it's valuable to understand these distinctions between HOAs and condos. So just take a look at this. Let me go back to this one, the HOA Act. So the purposes of this act, because keep in mind, HOAs existed and covenants existed before there was a statutory scheme that actually regulated HOAs. Before that, you were basically governed by Chapter 617. That's going to be the Florida not-for-profit statute, and it still applies. This is something that a lot of attorneys, even in this practice area, somehow don't understand. And let me explain to you as directors something that you might not understand. You are running a business by being on the board. Yes, I acknowledge you're volunteering. Yes, I acknowledge that that doesn't mean you know what you're doing. And yes, I acknowledge that as someone running that business, you may have no idea what you're doing. That's why you're here today. Okay, but you need to understand that making decisions on behalf of the association as a board member, as a director, you are making business decisions. So when you get the emotion involved in it and you say, I hate to put it this way, but you say, well, these are our neighbors, we have to be nice. You don't have to be nice. You have to follow the governing documents. And if you don't like what's in them, you have to change them by amending them. And if you can't amend them, you got to stick with what's in them. Because otherwise, trying to be nice just gets you in trouble. And I'll explain what I mean by that later. Okay, so, and this is not me being a jerk. Just understand, this is me telling you that it is your legal obligation as a director of a Florida Community Association, of an HOA in Florida, to do what is in the best interest of the association, even if it hurts you or hurts a buddy of yours, or hurts a neighbor that you just don't want to hurt. So let me reiterate that, because this is probably the most important thing that I will say throughout this entire presentation. You have what is called a fiduciary obligation to the association, to your HOA. What that means is that, again, you have a legal obligation to do what you reasonably believe to be in the best interest of the association, even if it hurts you. Okay, now, this is the highest duty imposed by Florida law. You're basically a trustee of the association. The good news is, again, it's reasonably believed. Now, if you're going against advice of professionals like attorneys, architects, things like that, that is not a reasonable belief. But if you're following those things, then you generally can't get yourself in trouble, which is why when people say, I don't want to spend the $150 to get a legal opinion on this issue, I think that those people are being penny wise and pound foolish, because what they're doing is saying it's not worth $150 or whatever the cost may be to ensure that we're doing this the right way. We won't get the association in trouble and cost everyone more money, and we won't have anything to rely on to say why our decision was reasonable. So if we get sued personally because of the decisions we made and the things we did as directors, we won't be protected, or we will be significantly less protected because we didn't want to spend the $150 to get an answer. So bottom line, if you're not sure what your rights are, what your obligations are, get the answer. It's fairly straightforward. It's an easy process. You send an email to your attorney. They should respond back fairly quickly. If you're using someone who takes 5-6 weeks to even acknowledge that you sent them an email, that's the wrong attorney for every community association in Florida. I'm just giving you a heads up now, because there are plenty of attorneys out there like me, like our firm. And well, maybe not plenty, but there are several law firms out there who will ensure that you're at least acknowledged within 24 hours. That's not a pitch for me. That's just a heads up that if that's the service that you're getting from your current counsel, you might want to look elsewhere. Now, the HOA Act is also intended to provide procedures for operating HOAs and protect the rights of the members without unduly impairing the ability of the association to perform its functions. The statutes that have come out in the last few years regarding HOAs and what they can and can't do are expressly the opposite of this point number 3 here. They're absolutely limiting the association's ability to perform its functions. But I'm going to stay off that soapbox for now. So 720 doesn't apply to property that is commercial, industrial, or other non-residential. So understand, you may still be governed by 617, you may still be governed by a declaration, but if you're not primarily a residential community, you are not an HOA that's governed by 720, which is the Florida statute that governs residential community associations. It also doesn't apply to the commercial industrial parcels within a residential HOA, or any community that is governed by Chapter 718, which is condos, 719, which is cooperatives, and 721, which is mobile home parks, except to the extent that a provision of 721 is timeshares. We frankly don't have to deal with them very often, so sometimes I forget 723 is mobile home. Except to the extent that Chapter 720 explicitly says, look at 718. So an example of that would be with respect to certain election disputes. Had to think of what the example would be, sorry. Certain election disputes, you're going to look to the procedure under 718 instead of just relying on 720 in that context. Realistically, that's something that you're going to run by your attorney. You shouldn't have to interpret any statutes. And frankly, if you do that legal interpretation, you're probably, I won't say probably, but you might be practicing law without a license if you then do that interpretation and give your opinion to the other directors. So just be careful as to what decisions you're making as to the legal complexities that might be involved in working with an HOA. The next question, okay, we decided Chapter 720 applies here. Which version? Are we talking about the Chapter 720 that existed when your community was created by recording the declaration in 1970, or the 2023 or 2024 version? Well, there's an analysis that attorneys do in determining that, but it's largely based on whether your declaration contains certain language. And we call it Kaufman language because this is language that was brought up in a case called Kaufman versus Scheer. And essentially that language is in item 3 here. Okay, it's as amended from time to time. If your declaration says that it incorporates either Chapter 617 or 720 or the HOA Act or something similar as amended from time to time, that's going to be a clear indicator to me. Shouldn't necessarily be something the board interprets, but it's going to clearly indicate to me that all statutory changes are going to be incorporated. Now, there is an analysis. The determination of if that language is not there is determined by, okay, well, does the new statute apply or not? This analysis is in here. Frankly, I usually go through it, but I've decided from now on I'm not going to because I think it's a waste of your time. In reality, if you're not sure which law applies, and you're not contacting your attorney, you're basically doing something very, very wrong. You're making a legal determination. Now, if you're a lawyer and you know this area of law, different story. But if you are brand new to this and you're taking this class as your first introduction to how HOAs operate, and you're trying to make a legal determination of which version of a statute applies or whether the statute versus your covenants will actually control, shouldn't be something that you're making the determination, even relying on these slides. So that should be something that goes to your attorney. So I'm going to skip through here, but I want you to at least be aware that you can't just look at the statutes this year and say, well, this is what we're going to do. You have to look at the statute, or frankly, you have to have your attorney look at the statute, determine whether the statute or your governing documents apply, and if it's the statute, which year's statutes apply. So this is an in-depth legal analysis. It may take your attorney 15 minutes to do it, but it's not something that the board, in my opinion, should be doing on its own. There are also conflicts between what's required of an association under Chapter 617. Again, that's the not-for-profit statute, and 720, which is the HOA statute. In the event of that type of conflict, where 720 says you do X, 617 says you do Y, you're going to follow 720 every time. Now, there are things that might appear to be a conflict, but which are actually just distinctions. So that's another thing you're going to want to run by your attorney and not unilaterally decide, well, Chapter 720 applies and Chapter 720 says this. That's a legal opinion. So make sure that you're running those things by counsel. Again, these are things that I want to make sure that you are aware of so that you know when that question needs to be asked. Now, a lot of boards will run this by their manager first to see if they can get an answer. Frankly, in a lot of instances, the manager shouldn't be giving that answer either, because they're not authorized to practice law either, just like you're not. But they will know in most instances when they should be reaching out to counsel and figuring out, hey, is this something we actually need a legal opinion on, or is it so clear and so common in Florida community associations that you don't even need to reach out to them? You can rely on an opinion you got 5 years ago because nothing's changed. Now, if your manager or your management firm is not attending a legal update class every year, don't rely on something from them that's based on 5 years ago. Just a heads up. So that legal update is something we offer every year that is also part of the elective classes that we teach. And just understand, when I mention those electives, they're not something we charge for. There's not something we earn money on. We're just providing them as a service to the industry as a whole, just like this class. We're just trying to help out. Conflicts between the declaration articles and bylaws. So we talked about conflicts between statute and governing documents. We talked about conflicts between statutes. Now we're talking about conflicts within your documents. So just remember the old expression, a little dab will do you. The DAB is the order that we're going to go in by order of importance and order of priority of your governing documents. So let me explain, because a lot of people don't know what these documents even are. And a lot of people, frankly, confuse them with each other. Your declaration. Now, we use that term because it's the name of most of these documents, but in reality, a lot of people refer to these as your CCRs, your CC&Rs, your covenants, conditions, restrictions, easements, all of the other stuff that goes in there. This is basically the association's constitution. Okay, it really is, and that's actually the wording that's used in certain Florida case law, that your community is a small government, and don't mistake me saying it's a small government with this being government action if the association acts, because that type of thing is not necessarily involved here. But you're basically a small community that is governed by a constitution. That's your declaration. That's the contract that binds the members. It runs with the land, meaning that it governs the entire property, even if someone sells their property. And it's basically that everything in this document is going to be presumed valid unless it's arbitrarily enforced, in which case it's invalid as to that individual owner or those individual owners, but not the community as a whole. Or if Florida case law or federal law or Florida law says this is an illegal provision. Other than that, everything that's in this declaration, if you've amended it instead of just establishing rules and regulations, is presumed to be valid. Then we have your articles. That's your articles of incorporation. This is a document that's basically going to say the name of the corporation, the purpose of the corporation, and the initial officers and place of business. Basically the equivalent of what you'll find if you look on sunbiz.org, which is the Florida Division of Corporations website. Frankly, that's the website we use every time that we need to perform a conflict check and get the director's information. So make sure also and I know GRS is good about this. Some other individual management firms are, individual managers are not. And some of the directors who are not using managers, which I don't know is the best idea, but is an option, don't actually update that information very frequently, and they really should. So just understand, you really should be updating the corporate records every time you have an election and the officers and or directors change. Basically immediately, you should be making that revision and amending what's in those records. Then you got your bylaws. This is what most people think governs the day-to-day operation, but that's really going to be your declaration. What this is really going to control is how the meetings are run, who your directors and officers can be, which is also going to be governed by Florida law, those directors and officers' responsibilities and things of that nature. So it's going to be your overarching, here's how the association's business operates versus here's how the community operates, which is really your declaration. Then you've got your rules and regulations, your architectural criteria, the policies and procedures that you should have in place, which I'll go through in a moment, which I think are the most crucial. And these are generally going to be made by the board without member approval. You just provide notice, you have something adopted, and that's the end of it. That means that they're going to be scrutinized more closely by the courts because, frankly, this is not something that you bought in necessarily expecting to have govern your community. Now, keep in mind, those rules and regulations, they need to be authorized in the declaration or the bylaws. So it can't just be something that's thrown out there out of nowhere. If it's not in the declaration or bylaws, it's probably not an enforceable rule. So what you want to do is have your attorney, every time you go to revise or establish those types of rules, the architectural criteria, or your policies and procedures, make sure that you're having your attorney take a look at that before it's adopted so that you know whether what you're putting in there is actually enforceable. I've had many communities who came in using other attorneys or not using an attorney who had 5 or 6 different policies, procedures, rules, and regulations in place, and none of them were enforceable because it was all stuff that, frankly, was not supported by the governing documents of this community. So what we do, we amend the governing documents so that it is supported. Now, if you think that you're going to have trouble amending because sometimes you need a 2/3 or a 75% vote, depending on your governing documents, to actually get an amendment. And when I say 2/3 or 75%, I mean of the entire community, except for those voting rights that have been suspended. That can be difficult. So your first thing you want to do if you have that problem or you think you'll have that problem, amend the amendment provision, amend the quorum provision, make it easier to do those amendments. Not so easy that it happens when every board turns over, but easy enough so that you can actually accomplish it. And then you go with your substantive changes. Now, I mentioned a couple policies, a couple procedures. My opinion is that every community association, regardless of HOA, condo, or how you operate or who you're working with, should have 4 policies in place. Now, you might want to write these down. It's up to you. I think everyone should have a collection policy that says, here's how we're going to collect money if you don't pay us, so that not every member of the community is left holding the bag for all of the unpaid assessments that everyone's just kind of sitting on. I have a community that literally told me they don't want to collect on anything until it reaches $20,000. That was like 6 years worth of assessments. They're already eliminating assessments they won't be able to collect by waiting that long, meaning they will never be able to collect. It's a bad idea. Okay, so you want to have a collection policy in place. You want it to automate that collection process so that you're not, frankly, being nice to some people and pursuing other people. Same thing with covenant enforcement. Someone is not mowing their lawn. They're not doing certain things they should be doing. You want to have a policy that says that type of thing automatically goes forward with actual enforcement. These 2 topics are actually the topics of classes that we teach. Those electives, you can find them on our website, or if you want to attend them live, we'll probably be teaching one or both in the next month or 2. I would strongly suggest that anyone that thinks that you should sit around and wait on these things and not take them extremely seriously, attend those classes so that you can understand why they're so important. And then the other ones are member participation at meetings, meaning how long do people have to speak? When are they allowed to speak? Are they allowed to basically take over your entire meeting so that you can't do any business? And then finally, records inspection requests. Those are the 4 that I think are the most crucial. Again, collection, enforcement, member speech at meetings, records inspections. So moving along, members' rights and meetings. The annual members meeting is basically your election. The bylaws are generally going to say when and where that meeting gets held, how to call it, etc. You might also have special member meetings. That's basically every other meeting that's held by the association. And that's really going to be when the board calls that type of meeting because there's something that the members need to vote on. For example, you need to amend the governing documents and it's mid-year and you don't want to wait for the end of the calendar year to get your election in place, etc. You want to do it right away. That's why you might schedule a special meeting. Or if a written request of at least 10% of the members or whatever percentage is in the documents is actually received by the association to hold that type of special meeting. Now, the statutes recently changed that it's to say that it's the owner's obligation to make sure that the association is aware of where notices of these types of meetings and board meetings and literally anything else is sent. Meaning that this was the law before, but I think it's more clear now that it's codified in Florida law in the statute that it's not your obligation as an association to chase down everyone and find out what their mailing address is, what their up-to-date email address is. It's the owner's obligation to say, hey, I won't be home for 8 months because I'm going out of the country. Here's my mailing address outside the country, or I will accept notices via email. Here's my email address. Okay. The statutes changed just this past year to clarify that it's not the association's responsibility to chase people down. The responsibility of the association ends when that notice is sent out, and it needs to be sent to the last mailing address that was provided. If the owner has never provided a mailing address to the association, all those notices just go to the property. Okay, another change that was recently made, every meeting now must have an agenda. Doesn't matter whether it's an annual meeting, a special meeting, a board meeting, a special board meeting. Doesn't matter. If it's a meeting of the association or of the board, it needs to have an agenda. There are special notice requirements as to the timing of that notice for certain types of meetings that are going to be held. For example, if you're going to hold your annual meeting or a member meeting, you need to give at least 14 days notice. Usually your board meetings are only 48 hours notice that needs to be provided. You do need to keep evidence, which is an affidavit, basically a form that gets signed and notarized saying, yes, I mailed these notices to everyone on this list on this date, and here's a copy of it attached, proving that the association sent out these notices and is holding a proper meeting. That needs to be mailed or delivered to the address identified as the mailing address in the records of the association. That's what we just talked about. The notice needs to provide the date, time, and location of the meeting so that people know where to show up if they actually want to attend this meeting. And then the association can, by a reasonable rule, meaning it's not just, well, we voted, it's you actually have at least a resolution in place of the board. It doesn't need to be in your bylaws or anything, but a procedure for conspicuously posting or repeatedly broadcasting notice and the agenda on CCTV. Broadcast notice is rarely used in my experience. If you need any help with that, it is certainly something we have experience in. It's just rare, so I won't go into detail about it. We talked about the meeting notices. Unless the governing documents require otherwise, the annual meeting notice doesn't need to include a description of the purpose, but it does need to include an agenda now as of last year. So just understand, you don't need to include, a detailed agenda. Chances are it's going to be, you basically open the meeting, confirm you have a quorum, which frankly, you shouldn't be opening the meeting, in my opinion, if you don't have a quorum already. The approval of last year's meeting minutes or the last member meeting minutes. Then you have whatever else you need to discuss, your election, and then you close it, and that's pretty much it. Same thing with special meetings. The difference is at a special meeting, you need to clarify the specific purpose for which the meeting's being called. Bottom line, it's really not that much different between one and the other at this point because agendas are required across the board. So don't rely on saying you don't have to include a description of the purpose. You still need an agenda for that meeting. And frankly, the easiest and best way of doing that, in my opinion, is to include the agenda along with the notice so that you don't have to try and remember, oh, that's right, we were supposed to, or we didn't have to include that specific notification. Moving forward, members do have the right to participate in meetings. They can attend, they can speak at the meeting for up to 3 minutes on any item. And keep in mind, you do have the ability, like I mentioned earlier, this is one of the policies that I think is crucial to adopt immediately before you have a problem. You can adopt reasonable rules governing frequency, duration, and other manner of owner statements during these meetings. The reason I say that you want to do it before you have a problem is because as soon as you have a problem, the person that is causing that problem is not going to enable you to actually conduct business during that meeting because they're not going to shut up. Okay, what you might need to do is have an attorney there who threatens to frankly sue them for nuisance or some other violation of your covenants, or have a police presence there and have the police officer remove that individual. But the initial step is making sure you have this policy in place so that it's clear what the members can and can't do during that meeting. You do need to hold that meeting at a location physically accessible to handicapped persons who otherwise wouldn't be able to attend and who have the right to attend if they request it. So we do have a Fair Housing Act class that I would also strongly recommend every director take. You notice the theme here? We have 20 classes or so that we offer. I really think you should be taking every one because these are issues that at some point you're going to have to deal with. And sometimes by attending that class for free, you can avoid the attorney's fees that we talked about earlier because you've got the answer directly in the notes that we're providing to you. Moving on. Member meetings, a quorum at a member meeting is 30% of the members or the total voting interests, unless your bylaws say otherwise. Decisions are a majority of the voting interests present in person or by proxy at that meeting where you've attained a quorum. Meaning, if your quorum is 30% of your membership, you need a majority of that 30% to actually show up and vote in favor of whatever you're trying to accomplish in order to make that decision as a membership. Okay, proxies. Here's some requirements. Frankly, you're going to want your attorney to prepare the proxy form so that you are, or at least review the proxy form that your management company is providing to you so that you know that it is something that complies with all these requirements. And that way you don't have to know everything that's in this slide and the next slide. Moving forward, flags are one thing that was changed last year and the year before. There are now certain flags that the association must allow to be flown. And I know that we're jumping around here from topic to topic. I promise we'll get a little bit more linear later on. But the homeowners may fly one U.S. flag and one flag from the list above from a freestanding flagpole, as well as 2 of the flags that are listed here on the residence itself. So just understand you could have someone with up to 4 flags at their property. And that is totally acceptable and allowed by Florida law. Just understand also that these flags are limited. So it's not you can fly whatever flag you want. The other thing to keep in mind is you can fly whatever flag you want if your covenants don't actually restrict flying flags or potentially posting signs. That one's a little bit iffy when it comes to treating flags as signs depending on the content of the flag. And when you get into the content, that also creates other issues that we don't want to talk about today. So I won't. Because lucky me, I get to decide what we're going to talk about today. Now, this is a law that came into place last year as well. It's another one of those terrible impositions on Florida community associations. Essentially, the law now states in Florida that if an HOA has a restriction that says you can't install X on your property or you can't store X on your property, that is not something you can enforce as an association if X is something that is not visible from the street, your frontage of the lot, or from an adjacent lot. Meaning, if you can't see it, you can't enforce it. Okay, that is now Florida law. It's a terrible law. I wish there was something we could do to repeal it, but apparently the government has bigger fish to fry as of right now, at least the Florida legislature. I would love to see someone willing to spend the $100,000 or more that it would take to get a constitutional challenge through the Florida Supreme Court on this issue. I just don't see anyone doing it. So as of now, this is what we're contending with. Some of the ways that I've figured out to kind of work around this, one of the things to keep in mind, if you can see it from across the lake, that's not an adjacent property. That's not a workaround. That's another problem, by the way. That's what we call a loophole for the owners. But the ways you can work around this are if someone is storing something that is causing other issues, not just the installation or the storage, but the actual problem. So for example, someone paves their entire backyard, not visible from the frontage, not visible from an adjacent lot. Technically not something the association can enforce under this law. But it starts to cause flooding because the installation of those pavers means there's no longer any drainage on that backyard. Well, now we've got something separate that we can enforce. So just understand, it's not conditions that this causes, it's the condition itself that the association will not be able to enforce as of right now. Another thing to keep in mind, it's the owner's burden to bring this up as a defense to a lawsuit. So keep in mind, the association is within its rights to take the risk, whether the owner is going to actually know enough to hire counsel and or raise this issue. There are other laws that we didn't mention, but I will now. The over-the-air device rule, OTARD, is basically a limitation on what you can restrict as to satellite dishes for TV signal. There's limitations on what you can restrict regarding energy devices, including digging into townhome roofs to install solar panels. There's the Florida-friendly landscaping, and I already mentioned the Fair Housing Act. Just understand there are certain things that your restrictions say someone can't do in your community. That doesn't mean that automatically that restriction applies. So just make sure that you are actually going forward and getting your opinions from your counsel before you decide to go gung-ho enforcing violations, or frankly, even rejecting applications for people to install certain things on their property pursuant to your architectural criteria. Moving forward, architectural standards are only enforceable. I just mentioned these architectural standards, and frankly, every HOA should have them. If you have any architectural restrictions in place, these are something that we can help you with if you want to adopt them, and your attorney should be able to help you with. But it's basically deciding what is and isn't allowed in your community. That needs to be either expressly stated or reasonably inferred from your governing documents or your architectural criteria. So you need to make sure that it's clear to the members what's going to be accepted and what's not in your community. If you don't have anything in writing saying that, you're getting yourself in trouble because you're not going to have anything that's enforceable, meaning when you reject that application, you deny it, the owner might sue you and win, saying they had no right to deny this application. Moving forward, if you're collecting deposits, they can't be commingled with any other funds. This is really going to be if you have the ability to collect deposits for construction work that's being done, tenants that are moving in that might cause damage to the community. The other thing I'll point out that isn't in the slides as an assistance matter is make sure that those governing documents, the portions that say that you need to actually pay out this type of deposit, make sure your documents say where that gets returned afterwards, because otherwise you can end up in the middle of a battle that has nothing to do with the association as to who is entitled to that money. Is it the landlord or the tenant? Is it the contractor or the owner, etc.? The other thing to keep in mind, if a member makes a request for an accounting as to how you dealt with those deposited funds that cannot be commingled, the association only has 7 days after receiving the request to provide that accounting. So just be careful, and that gets us into official records of the association. Now, I want to mention something that's not in here, but it is important to note. It's not in place yet, but the HOA database of all information regarding associations is going to be potentially something that gets adopted this year. It's a bill that is going through the legislature now, and it would require every officer director name and contact information, self-managed or manager contact information, copies of the governing documents, etc. All of this would be something that is required of every HOA in Florida. And unfortunately, it's also something that's potentially being required pursuant to federal law that's already been adopted, but doesn't technically kick in until December 31st of this year. So if you don't know about the Corporate Transparency Act, I strongly suggest you look at Jeff Rembaum's Roundup emails. It's available on our website, Rembaum's Roundup. You go to KBR Legal under resources, you'll see Rembaum's Roundup. There's an article about the Corporate Transparency Act. That is a federal act that's going to require a lot of the same information, but is a lot less clear, and it's really unclear why an HOA would be required to comply. So we're actually asking everyone to reach out to their legislators. I know that's not something that generally benefits you, but if you're a director and this is going to require you to send information to the federal government that is potentially accessible to other people, that is personal information about the people that control your community, which is the directors, I think you might want to consider whether it's important enough to send an email. So just take a look at Rembaum's Roundup. The Corporate Transparency Act article came out, I think, about 2-3 weeks ago. It's one of the first things that you'll see there. So I would strongly recommend that everyone take a look at that. Moving on to the actual official records, in addition to a roster of who's a member of the community, there's a bunch of information and documentation that the association needs to maintain. Now, the easiest way to do this is to have it all on your website behind login credentials and just basically be storing the files in some kind of organized fashion. One, that means that they're accessible to the board and your attorney and your manager when they're needed. And most of the time, if you are using a management firm, they're going to offer to provide this service for a charge. I think you should be taking advantage of that. That's just my personal opinion. But the other thing this does is make records inspection requests, another policy that I suggested you guys have, much easier and faster, because you can basically just say, hey, go to the website, everything is there. If there's anything you don't find, let us know. Rather than, hey, if you want to come in, here's 20 boxes worth of stuff, feel free to look through it and have at it. That way you don't even need to make the time available to the member. It's just, well, it's accessible to you whenever you want it. Go ahead and take a look. What these official records are, I'm going to skip everything except this last bullet point because that's the one that matters. All written records of the association that are not specifically identified in the statutes and the ones that are identified related to the operation of the association. So what this means is every piece of paper, every document, every piece of material related to the operation of the association is something that the association needs to keep. Now, that includes, by the way, your account ledgers that are accessible to the members via records inspection request. We'll get into why that's something to make sure to be aware of in a minute. But unless otherwise provided in the statute, the official records must be maintained for at least 7 years. One thing I will say, especially if they're digitized, keeping those forever is really not a big deal. And in a lot of circumstances, condos are actually required to do that already. And the legislature is moving HOA governance towards what condos are required to do. What I'm getting at here is it wouldn't surprise me in a couple of years if you see an HOA statute that says you need to maintain all official records of the association indefinitely, not just for these 7 years or different time frames that are listed in this breakdown. So just understand you really need to maintain your official records. Legally, they're not required to be maintained in any specific order, but there is legislation that is being put through potentially this year. There is a pending bill that would require you to actually organize them to make it easier for members to inspect them. I don't recall offhand whether that's condo specific or also HOA. Bottom line, if you're already having management maintain those on your website, you're probably doing the best thing you can be doing for your community. It's just easier that way. We already mentioned pretty much everything is included, so I'll skip this. Records that are not accessible to members. This is an important one because yes, everything is an official record. And generally speaking, those records are accessible to your members, but not everything. So anything that's protected by attorney-client or work product privilege is not going to be something that the members are entitled to. Okay, you can't just say, I'm a member of this community, I have a right to see what you're doing in the lawsuit you filed against me, or the lawsuit you filed against somebody else, or the lawsuit you're contemplating filing, or that you might get sued for. Okay, the next thing that is not accessible to members, medical records of owners or residents, that's generally speaking, just private information, information obtained in connection with the lease, sale, or other transfer of a parcel, same deal. Personnel records of association or management employees. That doesn't mean that their salaries are not disclosable. It just means that if it's personnel records, meaning something pertaining to their hiring worksheet, their intake worksheet, things like that, that's not something that the members need access to, and it's not something they get access to. Electronic security measures used to safeguard data, so your passwords, your login credentials. Obviously, you don't want to allow people to log into what the board is supposed to be seeing exclusively, management or the attorney is supposed to be seeing exclusively. And then same thing with software and the operating system. You don't want them to be able to manipulate the data, even if they can access it. So, for example, instead of producing that data, the raw data that they can then manipulate or log in credentials so they can manipulate it, you produce a printout that's prepared, a report that's prepared by QuickBooks or whatever your software is. So you can provide a report. Another thing to keep in mind, well, let's get through the other not accessible stuff and then I'll mention this. Personal identifying information, there's a whole list of stuff that's in here. You do need to produce the person's name, parcel designation, mailing address, and property address. Everything else that's personal is not accessible. And then information in a gated community regarding guest visits, again, personal information. And then affirmative acknowledgements pursuant to 720-3085. These are the ones that basically say, I will agree to accept invoices from the association in the new matter that the association is sending them to. Hopefully we'll have time to get to that later. If not, you're welcome to attend the the collection class that we put on, which is Should I Pay or Should I Go? Moving on, attorney-client privilege we talked about. Keep in mind, only the board gets to waive attorney-client privilege, not the attorney, not the manager, not any individual director or officer. The board needs to make the concrete decision that the board is going to waive that privilege. That is a privilege that is the association's privilege, not the board's privilege, not the member's privilege, not the individual's privilege. It is the association as a corporation. Because keep in mind, when we work with the association, we represent a corporation. We represent the entity itself. We don't represent individual directors. We don't, now that might be the case separately, but when we're working for an association, giving legal opinions or doing work for an association, we're working for the corporation, and the corporation is what enjoys that privilege. So our client is the association. The association's board is the one that gets to make the decision whether to waive that privilege or not. Moving forward, membership directories, there are certain restrictions on the availability of these documents. We won't get into that, but just understand the information's here. Availability and production. So this is a very, very, very important concept and is, again, one of the reasons why I suggest you have a policy governing how this goes, to make sure you don't get hit with what I call the $500 gift. Okay, let me explain what that means. You need to keep the records and make them available for inspection within 10 business days after you receive a written request to inspect those records, within 45 miles of the community or within the county or on your website. If the request is by certified mail, return receipt requested, and the records are not produced, that creates a rebuttable presumption that the association intentionally failed to disclose the records. A rebuttable presumption is one that shifts the burden, meaning that the association then becomes obligated to avoid these charges, which are attorney's fees and costs incurred by the owner that requested the records, as well as damages, either statutory or actual damages. The rebuttable presumption shifts the burden to the association to prove that this was not intentional. In other words, there was a flood in the records room, and as a result, we weren't able to provide the records, but we normally would have been able to, and we really tried to. But the owner wasn't willing to work with us because we had this issue. That's what it would take to prove that that was not an intentional failure to produce the records. Now, we see here the other ways that you can produce the records. One of them is electronically via the internet, like I said, or viewable on a computer screen and then printed upon request. You can have a computer just sitting in the management office or the association's clubhouse or wherever that, they kind of pick and choose out of the records what they want printed. Keep in mind, the association doesn't have an obligation to cherry pick those records. You don't have to look through and find these individual items the owner's asking for. All you have to do is produce the records, the entire universe of records for them to look into. If you don't, just understand that it is a $50 penalty per day. That is the statutory damages starting on business day 11 up through business day 20, meaning that is a $500 gift that you're giving the owner that you don't want to provide, plus their attorney's fees and costs. Okay, so just make sure that if you are producing these records, you're doing it within the time provided. Now, from a practical standpoint, something that people don't seem to understand either, you are offering to provide the records on a date and time and location that you specify. You don't have to sit here for 5 hours trying to coordinate a mutually acceptable date and time. Someone sends you this request, you respond, here's when your inspection will occur, be at this place, at this time, at this location, on this date. That's where your inspection will happen. If their response is, I can't be there at that time, okay, you're welcome to send another request. Or, well, I can't be there at this time, but I can be there at this other time. Up to the board whether you want to comply with that request. But as of by providing that date and time, you've technically complied with the majority of your requirement. The other part of that is actually being there on that date at that time in that place if the owner does decide to show up. Now, the policy, what you can include is listed here. Again, it's one that I think is almost necessary for every community in Florida, and it's one that I strongly suggest every community adopt. I don't require it for clients of our Orlando office, but frankly, I really think that it's something that is necessary, because if you don't have this here, then the likelihood that you're going to do this wrong and get the association in trouble becomes increasingly problematic. You can't require the owner to show a purpose for the inspection. You can't have them state a reason. It's just, well, you know what? This is what we want to inspect. Okay, great. We're going to let you inspect the records, period, except for those that are accepted like we discussed before. You can charge fees. Those should be adopted in a written policy, and they're restricted by Florida law. So again, have your attorney review or prepare that policy. You can't charge for copying less than 25 pages, and you must allow someone to come in with their cell phone, tablet, scanner, whatever, so that they don't have to pay for those copies if that is something that they want to do. We talked about what happens if you don't provide these on time, and now we get to move on to your elections. Okay, so this is actually fairly straightforward. 90% of the election process in an HOA in Florida is have your attorney tell you what the bylaws say. Follow the bylaws. Good job. Election's done. That really is pretty much, I mean, it sounds very simple. It's not necessarily that simple, because most bylaws are silent for the most part. And the ones that do say what to do, it's because one board decided we want the election process to be X, and it may or may not make sense to everyone other than that board who came after. So just understand your bylaws are going to govern most of what needs to be done in your election. To avoid disputes over the validity of the election result, make sure that before you eliminate nominations at the meeting, you actually ensure the documents don't allow for nominations at the floor. So some governing documents are silent on this. Some governing documents explicitly say that nominations are allowed from the floor. If you have a ballot that doesn't have blanks for the people that were nominated from the floor, you're guaranteeing that those people don't have the ability to actually be nominated. Now, I don't have a problem, although I'd prefer that you have a ballot with those blanks with the people that have already been nominated. But I don't have a problem with you basically having just an open spreadsheet and having people vote that way, as long as they're handing you the ballots. The other thing to make sure you're doing during your election meeting is close off the balloting at some point. That way you're not continuing to collect ballots at 9:30 at night. It's just not a good idea. You may still be counting them at that time, but if you're doing it right, and maybe you're using electronic voting, maybe you've collected some of the ballots in advance, it really shouldn't be a long, detailed meeting. I've been through community meetings that had 3,000 lots, and the meeting only took an hour and a half, 2 hours. That includes counting all the ballots that weren't submitted electronically. So just understand, you know, these are things that you want to think about before you hold your meeting, being prepared to do them the right way during the meeting. Election procedure is going to be what's in the bylaws. You need a quorum unless the bylaws say otherwise. If you can't have an election because you don't have whatever quorum requirement exists, meaning you can't have a vote or even a meeting at that point. The directors that are in place now just hold over for one more year, not one more term, one more year, regardless of whether you have staggered terms or not. In an HOA, you need to give 14-day notice before the election meeting unless the bylaws say otherwise, and generally anyone can serve on the board. Now, there are limitations in this slide as to who can't serve on the board. Anyone that's delinquent in payment of a monetary obligation on the last day they can nominate themselves, again, that might be the date of the election, is not eligible to serve on the board, and their name can't be listed on any ballot. Anyone that's been convicted of a felony or something that would have been a felony if it had occurred in Florida can't serve unless their civil rights have been restored for at least 5 years. And someone who has pending criminal charges for felony theft or embezzlement offenses involving association funds or property logically can't be elected to the board. Directors serve a 1-year term unless the governing documents say otherwise, meaning unless you have staggered terms or extended terms in your bylaws, chances are you just get reelected every single year. Not that everyone stays on the board, but that you have a new board that could be voted in every single year. Now, one thing that I've heard multiple times is, well, they haven't had an election in 5 years and those people are just in control. They're not holding elections. They're not doing anything right. They don't seem to give a crap about following proper procedure. As long as you provided notice, if you didn't get a quorum for 5 straight years, which in an HOA in Florida would not be an entire shock to me, you've done what you need to do, and it's not a problem, in my opinion, that you're not having an election meeting. You're scheduling an election meeting, or if you have requirements that you have to submit your name in advance, it may be that you have a 5-member board, only 5 people put their names in the proverbial hat, and there was no need to have an election because no one else could be nominated after a certain date. So obviously, there's no need to have that election meeting. You've only got 5 people running. You've got 5 people that are interested. They're on the board. Congrats. So moving forward, nominations from the floor we talked about. Election by acclamation is what I just mentioned, which is if you have the same number of vacancies as people that are interested and serving and are nominees, or if you have less nominees than available spots, you don't need to have an election. You just end up on the board. And then members have the right to vote in person or by proxy unless the governing documents say otherwise. If absentee ballots are allowed, meaning voting by proxy, the ballot must be placed in a blank inner envelope with no identifying markings and mailed or delivered to the association in outer envelope. Basically, what we're doing here is ensuring that all of the ballots and proxies are kept to the extent possible, basically anonymous. I know of many communities that don't want that anonymity. If your bylaws say that it's not anonymous, I don't necessarily have a problem with that. So moving along, election challenges need to be filed within 60 days after the date the election results are announced. So if you had a meeting on the 1st of January, you have 60 days, and the election results were announced the next day, you have 60 days from the 2nd. If the election results were announced, as it usually is, during the meeting, then you have 60 days from the 1st of January. And the venue to file that kind of challenge is either in a court in Florida, in the county where the community is located, or with the Division of Arbitration. And that arbitration can be a very tedious and drawn out process. So just understand, generally speaking, my personal opinion, and I think many at the firm share this opinion, is going to be that if you can avoid arbitration, you probably should. Getting into electronic voting, I'll be very brief. You want to use a vendor that your attorney trusts. That's all I have to say about it. Because the reality is the vendor is going to be taking care of making sure all of this is done. Your attorney has probably vetted that vendor to ensure that they are complying with all of these requirements. And frankly, the electronic voting is just something that can help the community. A lot of the vendors will actually swap the cost of printing and mailing the ballots as what they're charging the association. So if you're thinking this is automatically something that will cost significantly more, it may already be in your budget. You just don't know it. It's worth even having a meeting if you think that your members will agree to this. Now, that's the important part that I do want to mention, is that only those members who actually agree to vote electronically are going to be eligible and required to vote that way. For anyone that doesn't agree to that, basically opt into it, Keep in mind, you'll still need to send your standard notices, your standard proxies, ballots, etc., to everyone else in the community. So just be aware that that is something that needs to be done. Is it's not just you adopt electronic voting and everyone in the community has to do it. It's you adopt electronic voting and there's probably going to be a good portion of your members who actually adopt that type of balloting voting system. Now, the other nice thing about electronic voting is it facilitates electronic meetings and electronic notices. Because if you've got a good vendor who I can provide, but I won't mention names during this seminar because that's not the subject matter today. But if you do have a good vendor, they'll also take the time to go out and try and gather all of the opt-in forms so that you can provide electronic notices going forward and electronic voting going forward to as many of your members as possible, because that's how they make more money. And it's also how you save time by not having your manager or your directors directly have to stuff envelopes, mail them out, etc. You just send emails and someone clicks through on their phone or their computer or their tablet and their vote is done. And you've got that person counting towards a quorum who might not have taken the time to collect their mail, fill out the ballot form, fill out the proxy form, mail it back, or hand deliver it to the manager. So that's all I'm going to say about electronic voting. Electronic election of officers is generally done by the board during what we call an organizational meeting immediately following the election meeting. So that's basically going to be on the same notice, and probably the agenda is going to immediately follow the agenda for the election meeting. Directors can't vote by proxy or secret ballot at a board meeting, except secret ballots can be used in electing officers. Frankly, most of the time, from what I've seen in community associations in Florida, it's just, we want John to be the president. Anyone else in favor? Aye. Okay, we've got a second. Does anyone else want to be president? Heck no. Okay, John's president. That's the way the vote goes. So, and obviously each member of the board should be voting, but it's basically that straightforward. Now, we have the question here, does the president vote? The answer is no. You're probably wearing 3 hats in your community if you're a director. Okay, one is you're a member. You're an owner in the community. When I say member, that's all I mean. Someone that owns one of the lots in the community. You're a director, meaning that you make motions, second motions, discuss the motions, vote on motions, or abstain if you have a conflict. That's all directors do. Okay. The officers, including the president, are the ones that have specific responsibilities. And if you have a manager, chances are that manager's taking on most of those responsibilities. So when you say the board president, that is a non-existent item. The board president doesn't exist. The president, who's also a director, probably does exist. So just understand 3 different hats. Okay, the members are the ones that don't really have rights to do very much in the community to make decisions except at member meetings. Now, what requires a member vote or not is generally going to be governed by the declaration as well. The directors are the ones that are going to make most of the decisions, and the officers have specific responsibilities and duties. So just understand those 3 hats that you might wear. Now, one way of going and fixing a problem, if you've got a president who's decided to go rogue and do whatever the heck they want in the community because they're the president and they get to make decisions, no, unless that authority was delegated to the president by the board, they don't have that authority. And so what you can do is change officers midstream. Basically say, listen, this person is causing problems in our community by making decisions that were not authorized by the board. We want it to be clear that they don't have that authority. We've explained to them they don't have the authority, and they continue doing it. So as a board, we are going to decide, because there's an agenda item on the agenda that says changing officers or something similar, we are going to take this person out of the president's position and either make them only a director or a different officer position. So just understand you can change officers midstream. Now we're going to start going a little faster because we're an hour in and we only have another hour left, and I'm on slide 43. So if I start talking really fast, just understand I apologize. You'll get the slides later, and I will be able to skip some of the material because we have the ability to do that. Some of the stuff I'm going to skip is what we have other classes on that I'll say, watch our class on this instead of going through it today. Now, fraudulent voting activities, that hopefully will never happen by anyone or to anyone that's attending today, but there is an entire list of activities that are now officially deemed fraudulent as of October of 2023. I won't go through them in detail, but I do strongly suggest you read through them so that you understand what you can and can't do with respect to your elections. Frankly, if you're managed, your manager should be handling most of what needs to be done, if not almost everything, with respect to your election. Moving on, we talked about the many hats that everyone in this meeting might wear. We talked about your fiduciary duty. The other thing that we didn't mention that I think is one of the most important things you can know about is directors and officers liability insurance. If you don't have it, get it now for your association, because that's what's going to protect your officers and directors beyond whatever indemnification that's provided in your governing documents, if any. But it's basically an insurance policy that says if the directors are alleged to have done something wrong as directors in their capacity as directors, they are protected by this policy. I consider that your second most important bill that you will ever get, maybe third, because your most important one obviously is going to be mine, but that kind of flip-flops depending on what you need with your manager's bill, because frankly, that's the person that's providing probably the most service out of any vendor that the association works with to protect the association and ensure that you're doing things the right way. And if you work with a good manager, and my experience has been everyone that I've ever worked with at GRS does a fantastic job, by the way. There are plenty of other great management firms out there, but I think they do a fantastic job, and that's not me blowing smoke just because they're supporting us here today. I would have just said nothing if that weren't the case. So just to be clear, if you're not working with them, they are definitely a community association management firm that you should be reaching out, especially if you are currently self-managed and need some help, because they will make sure that these things get handled properly and they don't have a problem going to counsel when necessary, which so many managers choose not to do because they think that it's saving you money. And in fact, it's costing you money in the long run. Courtney, did you have something you wanted to add, or you were just popping in?
No, I was just hopping on because I wanted to thank you for saying all that nice stuff about us.
No problem.
And
again,
I'm not just gonna blow smoke. Kaye Rembaum is my favorite attorney to work with. I love you guys so much. You guys are amazing. And this has been so informative so far. I thank you everyone for bearing with us. I know it's a long one, but there's so much information. All right, continue.
All right, thanks, Courtney. So just understand, most of the power in a community association is held by the board. Again, you're going to look at your governing documents, or more appropriately, your attorney's going to look at your governing documents to determine what vote is actually needed. Is this a member decision or a board decision? Most of the votes that are going to be taken, most of the decisions that are going to need to be made for your community association, for your HOA, are going to be made by the board. So this is a really important position that most of you are sitting in that you might not have realized how important it was. The bottom line is you make 90% or more of the decisions for your community, which is why there are so many issues that the board just decides on versus the 1 to 2 member meetings you usually have per year. And frankly, the major issue that's decided by the members are amendments to the governing documents and your election. Almost everything else the board decides unilaterally. So moving forward, the board's responsible for the health, safety, and welfare of the community, meaning you guys decide how to operate and maintain the community itself, which is a very important job. Again, no one board member should be making decisions unless the board has already voted to say, for example, we're going to mediation. We don't want every director to have to attend this. We're going to delegate the authority to make settlement decisions to one director and the manager and the attorney. So if and in reality, it's just the director that makes the decision with the advice of the manager and the attorney. Okay, so that's the type of delegation we're talking about. You're holding a board meeting, you're making a decision, and you're actually expressly stating this person has authority to go up to X and make that decision on their own. Anything beyond that requires a further board meeting or a further board decision. Now, I haven't talked about board meetings yet and what they mean. We will in a minute, but I think it's important to mention that now because there is a lot of dispute as to what that actually means. What's a board meeting? So the board meeting is technically any time a quorum of directors, which is usually a majority, is meeting and conducting association business. Now, the problem with that is that that's the wording in the statute. Conducting association business. The statute has zero definition of what constitutes conducting association business. That's the problem. So some attorneys will tell you anytime a quorum of directors that is even discussing anything related remotely to the association, that's a board meeting. The members are entitled to notice and the members are entitled to attend. My personal opinion, that isn't necessarily one of my firm, of GRS, or of anyone other than me personally, is that it makes zero sense that the board members are entitled to communicate via email, but are not entitled to have the exact same communications, knowing that a vote won't be taken, which in my opinion is conducting association business. But it makes zero sense for the legislature to say, you can email to communicate and you can have the exact same communication via email. You just can't have that outside a board meeting without emailing it back and forth. So my personal opinion is, if you are solely conducting an information gathering session and you explicitly say, we will not make any decisions during this meeting, and we will have a full discussion of all of the available options during the board meeting when we will make the decision, then that information session is not a board meeting. Again, purely my opinion. I'm happy to put that in writing if any association that we represent needs it. But the bottom line is, there are many attorneys and probably some judges out there who will say otherwise, that anytime the board is meeting and discussing association business, that's a board meeting. I just don't agree. But that doesn't mean there's no risk associated with my personal legal opinion. Okay, moving on. Board voting and decisions. The directors basically vote the same way as the members. But you can't vote by proxy or secret ballot, except in the election of officers. The board, again, can use email as a means of communication, but can't vote via email. No director, even the president, should make unilateral decisions unless that power has been delegated or in emergency circumstances. We talked about the fiduciary duty and the reasonable business judgment that the directors have, and the fiduciary duty that also exists. Now, it's okay not to be right as a director. As a board even, it's okay not to be right. But if you're not relying on any concrete information and you just unilaterally decided, we think this is appropriate, then you're not really going to be protected by much other than the business judgment rule. And the business judgment rule says there needs to be reasonable business judgment. If you have zero experience in business, you've taken this class, good for you. But that's this class, this 2 hours is the extent of your knowledge about how to run a community association or a business as a whole. And you decide on things without consulting with your manager, without consulting with counsel, without consulting with architects if they're needed, you're not going to be protected by that business judgment rule very long. So just understand, yes, you need to use your business judgment. You also need to have something that you are relying on in making that business judgment. Again, no emotional decisions. Okay, you're making business decisions. So moving on from that, we mentioned that all agenda items need to be included except in emergencies for all association meetings. I don't know why this looks the way it does, but I apologize. Meeting notice is generally 48 hours for board meetings. The only exceptions are if you're changing the actual use restrictions in the community, meaning you're adopting architectural criteria or something of that nature, or if the board is voting because the board has the unilateral authority in the governing documents to amend those documents, whereas normally the members get to vote on something like that. That's something that'll require additional notice. Those are all 14 days notice. The other one is special assessments that might be levied. Okay, you need 14 days notice, and that notice needs to specify the nature of the assessment. What are you charging for? What's the dollar figure you anticipate? Okay, things of that nature all need to be included in that notice, and it's not the standard 48 hours. So again, most of the time, 48 hours, specific changes to parcel use or special assessments, 14 days, just like a member meeting. You can post the notice on the association website or through an app if you've adopted reasonable rules that say you will do that, and people have opted into it. No compensation for directors in general, and no other benefits except for the following. Now, this is just a list. Anything beyond this is labeled as basically a kickback, although that term is in the statute now as of this past year, but is not defined in the statute. But any of these items that are listed in this slide that I'll give you just a second to read, I'm not going to read them to you, but basically you're not allowed to accept any benefit except for the benefits that everyone else gets or related to some kind of course. Okay, no kickbacks. This has been the law in condo land for a while, and this is in red because it was added this past year. You can't accept anything of value or kickback, which I don't know what the difference is, but for which consideration hasn't been provided for your own benefit or a family member's benefit. Bottom line, you can't accept anything of value unless you are accepting it as a member of the community who everyone got it. I'm not going to get into detail. We have a conflicts of interest webinar, and I'm going to suggest you take that if you want more information about this one. And it is one that I teach. This is not a lack of knowledge, but frankly, I don't know how to expedite explaining all this. So I'm just going to leave it out for now, but you will have the slides. Immediate removal if you forge a ballot envelope, steal money and or property of the association, destroy records so that someone can't access them, and obstruction of justice. Those are all reasons you'll be removed from office. Now, there are required conflict of interest disclosures. What a conflict is not bad. Okay, it's not automatically a negative to have a conflict. You might have a cousin who runs a landscaping company who's going to give a great deal to the entire community because they want to help out their cousin. There's nothing wrong with that. But what you do need to do is disclose that relationship with the potential vendor to the board, to the members, have at least 2/3 of the other directors vote in favor of it in order to pass it, and also make sure that all of the members are notified and that you abstain from the discussion and the voting by the board on that potential contract. Okay, so just understand, if you have a conflict, that is the only time you should be abstaining from the discussion and vote. It shouldn't be, I don't like what the board is doing, so I'll abstain. If you don't like it, vote against the decision. Okay. Moving forward, contracts between the association and a director. Again, this is the most clear conflict. Okay. This is absolutely, there is a conflict of interest. You are doing the work for the association. Again, nothing wrong with it. You might get the best deal, but you still need to disclose it. The other thing that I'll point out here is if the members cancel the contract, which they have the right to do at the next meeting following the adoption of this contract by the board, the association's only liable for the reasonable value of goods and services provided through the date of cancellation. So if there's some kind of termination clause in that contract, the board isn't held, or the association's not held to that termination provision and doesn't have to pay all the additional fees. The vendor just gets what it would have gotten and what it's entitled to through the date of the termination. Now, we have explanation of what a relative is and the degrees of consanguinity. I'm not going to go into this. And frankly, if you have a potential, let me step back. You know what a conflict looks like. You know what it is. You know if it's something you should disclose. If you're not sure, then you know you should disclose it. So I don't need to go into detail, but if you have any questions, this is another one of those, just reach out to me. I'm happy to answer these questions as to whether XYZ is or is not a conflict that requires some additional disclosures. Moving on, you are guilty until proven innocent if you are indicted and charged by information with a felony theft or embezzlement offense involving association funds or property. You are also removed from office at that point until there is a determination of no guilt. So basically the charges have to be dropped, or you have to actually go through the entire criminal process and be found not guilty in order to be reinstated on the board. We talked about gifts. Those are kickbacks. Gifts are slightly different. You can accept food to be consumed at a business meeting with a value of less than $25 per individual. So I can take you guys out. Not that I necessarily would take everyone on the call because we've got over 100 people here, but I can take someone out and discuss business at, let's say, well, Steak and Shake maybe something a little nicer. But if we're going to Ruth's Chris, we might have a problem with this rule. The other thing is if you are accepting services or goods like our little swag that we bring to all the conferences and things like that, you can accept that in connection with trade fairs or educational programs. Okay, so that's the reason that we are allowed to bring that swag to those types of trade fairs and things like that, trade shows. Vacancies on the board. If it's created as a vacancy, meaning someone is coming off the board. If the director's term expired, that gets filled by an election, which needs to occur on the date of the annual meeting. If there's a vacancy before the end of a term, meaning not at the election, unless the bylaws say otherwise, that can be filled by a majority of the remaining directors. So basically you get appointed. Do not hold an election just to appoint a director if you have the ability to appoint. All you're doing is throwing association money away. And I understand some people think, oh yeah, we want to hold the election so that we have the perception that, you know, everything was done above board. But the reality is you had a board meeting because you had to do that in order to appoint this person anyway. Everyone had the ability to come in and say their fair share. And frankly, if you're doing it during the middle of a term, that person's only serving out the rest of the year, chances are anyway, and meaning that you're sitting here and spending hundreds to thousands of dollars so that you look good when the difference is what, 6 months worth of service on the board. Member participation at board meetings, basically the same as member participation at member meetings. The only difference is they don't get to vote. And again, this policy that I recommend you have is also applicable to board meetings for that reason. Recording and handicap access. An owner can actually record or videotape any member meeting or board meeting. Okay, you can adopt rules, which is one of the ones that I put in there when I prepare these policies governing member meetings and board meetings. And if someone requests access because of a handicap, you have to provide that. Again, Fair Housing Act class, we teach it. It's great. Check that out for more information regarding how to address handicapped individuals, people with a disability. Frankly, that's another policy that I think is extremely helpful. The difference there is that you're not restricting how the members act. You are designating a basically a timeline for how you're going to deal with requests for accommodations of your rules or modifications to your property or community. You can also have committees. There's nothing that says you can't have these. The board's entitled to create board committees or advisory committees. Any decision that is being made during committee meetings, or I'm sorry, if that committee is going to decide how to spend association funds or is going to decide recommendations to the board, that committee meeting is something that needs to be open to the members, unless there's some reason to close it off. Now, we haven't talked about why you can close meetings to the members, meaning only the board and the attorney or someone else is entitled to attend. If it is an attorney-client discussion regarding potential or ongoing litigation, that can be a closed meeting that only the attorney who needs to be there. It can't just be, we're going to discuss litigation, so that's closed to the members. That's a problem I see a lot of associations getting themselves into. Yes, it can be closed, but only if the discussion is with counsel. The reason that that's closed is to protect the attorney-client privilege. If there's no attorney involved, where's the privilege arising? Okay, so just understand that. The other one is personnel matters being decided upon. That's not which staff of management you want to go with. That's not which management firm you want to go with. That's actually hiring employees of the association. Excuse me, those meetings can also be closed to the members. Okay, conflict of interest disclosures by the developer. Basically, the developer's representatives on the board need to disclose that they are related to the developer, not familial, but generally related. They work for the developer once a year. That's the new law that went into place. We talked about what is and isn't a board meeting, so I'll skip this. How to get off the board. A recall, which is basically a vote of the members to remove someone mid-term. And by the way, when your bylaws say that if someone doesn't show up to a certain amount of meetings and you say, great, we'll remove them because they haven't shown up for that amount of meetings as a director, that may not be good enough. It may be that a recall is the only way to get them off. You're going to off the board. You're going to want to consult with your attorney regarding that. Failure to take this class and send the certificate or send the other lying certificate to the secretary or the manager is another reason. criminal charges, receipt of an excessive gift, resigning in writing, obviously, is a reason that someone is off the board, becoming more than 90 days delinquent in the payment of any monetary obligation to the association is another important one. You don't pay your assessments, you don't get to stay on the board and make decisions for a community that you're not paying. You're off automatically, no questions asked. Now, the other way you can get off, unfortunately, is if you pass away. I really hope you're not keeping deceased individuals on your board. Moving forward, we're going to have to skip these, but they are important. If you don't know what any of these mean, please reach out. But some of them we're going to cover here today. Minutes. The only thing that I will cover with respect to minutes is they are not, I will repeat, they are not a verbatim discussion of what was discussed during the meeting. John Smith, as a resident, got up and said X, Y, Z. No. Your meeting minutes are, here's the motion, here's who made it, here's who seconded it, here's how every director voted. Here's the decision that was made, period, for each agenda item or each motion that's made during the meeting. That's it. So they're not verbatim records of what was discussed. Now, all meetings should have minutes taken. The other option we discussed, okay, well, what is a board meeting, what's not? If you need to make decisions in between board meetings, the other option, or if something arises during a board meeting, the board wants to decide and it's not on the agenda, which it's required to be. Some of the things that you can do to still fix this issue, make the decision that you wanted to make, are: one, you ratify the decision at the next board meeting. That's not something you should be using often. And the reason is that technically you're doing it wrong. It's allowed, but it's kind of a, well, we can skate by with this. Ratification is basically at the next board meeting, you act as though you're starting from scratch, making the discussion or making the decision, even though you've already done it. So we've got a vendor that's telling us they're going to pull their rate and increase it by $3,000 if we don't sign this contract today. We all want to sign it. We all agree via email. We want to sign it, but we still have to have some kind of decision made that we can't make via email and we can't make over the phone. So we're going to make the decision. The president gets to sign and we ratify it at the next meeting. Be careful with that, okay? Because if someone changes their opinion in the middle of the stream after you've signed that contract, that director might be in a little bit of trouble. That president might be in a little bit of trouble for having signed something that they weren't authorized to sign. They can say that the directors told me it was okay, but just be careful. Now, the other thing you can do is a written agreement, basically a written resolution. If it's signed by all the directors, unless your bylaws or articles say you can't do it, Chapter 617, which is the not-for-profit statute that, again, many attorneys don't know they can do this, but Chapter 617 basically says you can have a written resolution signed by all directors that vote unanimously and approve this and decide to move forward with that contract. Okay, a lot of times what I have going on is when someone wants to work with our firm, but they aren't having a board meeting for 6 months, that is a bad idea. And that's frankly one of the reasons I want to work with those people and clean that issue up. But they're not having a board meeting, let's say, for another month, but they want us to get to work right away. One of the things that I can do is take a quick look at their articles of incorporation, make sure that they're not prohibited from doing this, which they're allowed to do it unless the articles or bylaws say they can't. Prepare that resolution and send it for digital signature by all the directors. So within an hour or so, it's passed along, everyone signed it, and now they can sign that representation agreement so that they can work with us. Okay, it's that type of situation that you want to use it for, where it's, we really need to get this done in between, or I don't recommend it for this purpose, but because it fully replaces a board meeting under Florida law, it could be something that you frankly know where the board's headed. Everyone is already unanimous and you don't want the discussion. That's a bad idea, but there's nothing in Florida law that says you can't use it for that purpose. I strongly recommend against it because you want to be open and transparent to the members, but I have seen some people use this for that purpose. Moving forward, you generally don't have access to the parcels individually unless your governing documents say that you do, unlike a condo that automatically has access. We talk about material alterations. Basically, that means you're changing the appearance of one of the common areas in your community. It doesn't the Florida law doesn't require member approval before you make those changes. It does in a condo context, but the governing documents may require a member vote, and this is what you'll want to look for in your governing documents. Either if there is a change being made to the visible aspect of the community, or one of the more important ones that you might see more frequently is a specific dollar figure being spent by the association, or a specific percent of the budget being spent by the board does require a member vote. So look out for those things, but generally speaking, you don't need to get member approval. The other thing is there's Florida case law that says you don't need member approval if the purpose of the alteration, even though it changes the appearance, is to protect the association. I won't go into detail on that, but that's the bottom line. You might be able to kind of get around that restriction, even if you have a requirement in your governing documents to get member approval. Pardon me. Amending the governing documents we talked about earlier, you're generally going to require 2/3 of all votes in the community rather than just a majority of a quorum. You might have different percentages in your governing documents. If you do, then whatever's in your governing documents is going to control. Now, keep in mind, it's rare but does happen that your bylaws govern how to amend your declaration. Usually, each document says how that document gets amended. Just make sure that your attorney is taking a look at all of the documents to make sure they're not missing some procedure that's required, which could invalidate your amendment. The format, we do the underline and strikeout to designate what we're changing. Underline is new language, strikeout is old language that's being taken out. Or you can just say substantial rewording, see governing documents for current text, if that's actually going to be more confusing, which in many instances it is. We want the members to understand what they're voting on, which is why in the proxy, yes, we're providing the proposed amendment most of the time, but the proxy form that they're actually using to vote, basically the ballot for the amendment, is going to outline in like one paragraph or 1 or 2 sentences what the change actually is and what it means for them. We have the issue of lender consent. That's not something you'll need to worry about unless you're changing provisions impacting lenders, but that's one that you'll want to run by your attorney. Is this something we need to run by lenders or take a risk? And then developers can't exercise unilateral amendment power if that amendment would alter the general plan of development. And that makes sense. You buy into this community, you don't want the developer to unilaterally have the right to say, well, you bought into this community, it was going to be a 55 and over, but now we're going to cater to families primarily. I'm sorry, it's now 55 and better. The effective date of the amendment is after it's recorded in the county public records. And within 30 days after it's recorded, you do need to provide a copy of the recorded document to the members. The alternative, if you've provided a copy of what you're proposing to amend to, in other words, the document itself, in advance of the meeting when the amendment was voted on, then you can just provide a notice that the recording information is here. And basically that's just a postcard that goes out to all the members. Let's see, leasing restrictions might not apply to everyone across the board. Just understand there were changes in 2021 to the Florida statutes that affect short-term rentals, but if it's a general leasing restriction, it will normally only apply to those members who actually agreed to accept that leasing restriction on their individual lot or who bought in after the amendment took place. So just understand it's leasing restrictions are easy to amend if you can get the vote, but they might not apply to everyone even if you get the vote. So just understand it gets a little complicated, and you might need to track who bought in when to determine whether each individual lot is actually subjected to these amendments. Guest restrictions is another class that we do teach, and I teach it fairly regularly, and we'll go into this in more detail, but for now I'll skip it. Rules and regulations, and I say I'll skip it because it's 343 and I'm at slide 73 of 188. So we're going to speed along here. Rules and regulations are made by the board. They need to be authorized by the governing documents. The definition of governing documents now includes these rules and restrictions. They might be something you should record, but that statute was then changed again. So my suggestion is record them so everyone is on notice of what's in your rules and restrictions, but understand if you go to that time and expense, you'll have to record every change to those rules and regulations before that changed version, the amendment or the addition, is actually effective as to literally anyone, just like your amendments. Rule adoption, I basically said you give 14 days notice, board gets to vote, and that's pretty much it. Marketable Record Title Act is something that everyone should know about. It's basically a rule that says, and when I say a rule, it's a statute that says that 30 years from the date of recording the first transfer of each lot in the community, we usually go by the declaration because obviously that's easier than calculating that date for each lot. But 30 years after the initial recording of the declaration and those covenants will expire unless the association does something called a preservation to ensure that they remain in effect. If you haven't done that within the 30 years, then you have to go to a different process called revitalization. That's a lot more complicated. Preservation just requires your attorney prepares a document. It outlines what recording information exists for your existing covenants that you want to preserve. The members will have to actually vote if you go with the revitalization instead. So if you don't do what you're supposed to do in the right amount of time, that revitalization is going to be necessary, and that is a costly and time-consuming process. So basically, get the preservation in. We usually follow up with all our clients for about 5 years before this is going to happen. If you're working with my Orlando office in particular, our governing document book is actually going to outline the specific date when that needs to be done, so that every time you look at your governing documents that I've provided to you, you can actually see when that date is coming up. But we do provide notices in advance. So I think that's the end of it. You do need to let process servers into the community, so be aware of that. And that's people that are trying to serve a legal document involved in a lawsuit. So you need to let those people into the community, even if you have a gate. Licensed managers required under certain circumstances, and that is essentially when that manager's work is done for payment and the association served contains more than 10 units or has a budget in excess of $100,000. Now, understand, even though I think it's a good idea, that doesn't mean you have to have a manager. It means that someone who is managing that type of community and being paid for it has to have a license. That's all. Management standards and indemnity, just look at your management contract to see what they will be liable for, because frankly, and I shouldn't be saying this on a management company's webinar, however, just be aware that most of them basically say we're not liable for anything unless we really, really screw up. So have your attorney take a look at that. It may be industry standard and nothing that should be changed or can be changed, but you're going to want to at least know what that management company you're using or that individual manager you're using is actually going to be responsible for if they make a mistake. And my experience has been that in the rare instance that most management companies do make a mistake, they make up for it anyway, even if the contract doesn't require it, because they don't like losing clients and having attorneys see them as anything less than fully professional. Construction defects. If your community is relatively new, and when I say relatively new, I mean if it was created in the last 10 years, you're going to want to make sure that you run the issue of, are there any things we need to do by your attorney with respect to construction defects? Because it used to be that you had 20 years to file a lawsuit regarding a construction defect in the community. Then it went down to 7. And in 2023, it went down to, it was 10. Then it went down to 7 years, regardless of whether turnover has occurred or not. It's based on the date of the certificate of occupancy. So the first date that someone was able to move into that community, you got 7 years from that date, or July 1st of 2024, depending on certain factors, to actually file that lawsuit against the developer. So make sure that you've got your engineers coming in, taking a look at everything. If you know of any issues whatsoever, talk to your attorney about it. See what rights the association has. Again, we have someone in-house that can guide you through that process. His name's Jeff Green, and he's phenomenal. But regardless of who you're working with, just make sure that you've got someone taking a look at these issues so that you're not giving up claims that might be worth $100,000 and work that needs to be performed in your community isn't paid for by your members instead of the person that caused the problem being the developer. Emergency powers. I'm going to skip through these, but I will mention the association has a ton of powers that kick in that are different from what's in the general statutes and in your governing documents, if there is a state of emergency declared that might cause a problem in your community, might cause damage or, let's see, what's the word? Injury or damage. Okay, now this used to be primarily for hurricanes because we're in Florida. Now it's also for pandemics. Okay, this was changed a couple of years ago in 2021 to basically say if there's any damage or injury whatsoever that might be caused by this state of emergency, that these emergency powers kick in. The powers stay in place until that state of emergency is no longer in effect. The state of emergency itself could be statewide, nationwide, countywide, citywide, or basically any municipal, any governmental entity saying that there is a state of emergency declared is all that's required for these to kick in. So let's move forward. And I'm trying to get through as much as I can. We're going to make sure that we get through enough that you guys get your credit, but I'm trying to get through as much as I can to teach you guys the information here. I won't go through driver's license. Budgets. One of the most important things I can say about your budget, make sure it actually covers everything that you need to do in your community throughout that next year. If you need to increase your budget by $1 million compared to last year, increase it by $1 million. Let the members decide that they don't want to pay that. The members are allowed to propose an alternative budget if they don't like what's in yours. Okay, but you are the one as a director with a fiduciary responsibility to make sure that that budget contains everything the association reasonably anticipates that it will need financially to properly maintain and operate that community throughout the course of the year. The other thing I'll point out, don't back into your budget. Don't say, well, our budget was for this, so we can't do anything else. It's one thing if you don't have the funds available to do something else, but don't say we're not going to pursue these violations or these collection matters because in reality, we just don't have the money for it. There are ways around those things, okay? You want to make sure that you're doing what's necessary. The other thing is don't defer maintenance or repairs because it'll cost a bunch of money and you don't want to have to levy a special assessment or include it in your budget. Because what's going to happen is when you wait longer and longer, there's more and more damage, and a repair that would have cost 10 grand that you didn't want to spend is now going to cost $1 million. Okay, or let's say 300,000. Because I've seen that literal number, 10 grand versus 300 grand, I've seen happen with a community that got an estimate and waited 4 years to do the work. So just understand, do what you need to do to properly operate and maintain your community. That is your fiduciary responsibility to that community and to the association corporation. Notice and adoption of the budget, you need to provide notice. You can consider sending it to all members prior to adoption so that they do have the ability to say, oh my God, this budget's going up $1 million. And your response is, yes, that's what we have to do in order to properly operate and maintain the community. The alternative is you basically send your regular meeting notice and then you send a copy of the budget afterwards or say that a copy is available for inspection. I think that's the wrong way to do it. After the budget's adopted, the association provides a copy or a written notice, like I said, that a copy is available at request at no charge to the member. So this is not a records inspection, even though it's handled the same way. This is a copy is available. We talked about the budget, 2 main sections that need to be in it. I'm going to skip through a lot of this because realistically, what you're putting in your budget is what you reasonably think that you're going to spend and the reasonable amounts that you think you're going to bring in. We're going to skip through reserves other than to say this is money that the association is putting away for work that's not going to be done this year, but is anticipated in the future. It's not required in an HOA unless your governing documents say that it's required or the developer decided it's required and put that in documentation somewhere, or the members decide that it's going to be required. So bottom line, just make sure that you're accounting for everything you think you'll need. Computing for reserves, realistically, you're going to use your accountant and your manager for 99% of what we're talking about now. If you don't have a manager and you don't have an accountant, then you're going to want to reach out to some people and find one of each of those. If you don't want a community manager, then at least rely on your accountant and your attorney. If you don't have one of those, you reach out to me. Moving on, waiving and partially funding or terminating reserves are a member vote, not a board vote. Special assessments we talked about, so we're going to skip through that. I'm going to skip through financial reporting as well. Just understand, again, your accountant should be preparing these financial reports. The important part here is once your accountant or other professional or other individual prepares these financial reports, you're going to need to get them out to the members no later than 120 days after the end of the fiscal year. And if you're not using a third party to prepare it, meaning some kind of accountant or outside person, you only have 90 days after the end of the fiscal year, meaning by, I guess, March, depending on when you have your fiscal year, whether it's a calendar year or you start, let's say, in November. So just be careful. These are different financial reporting levels. What we say is basically mo money, mo problems. If you've got 150,000 or more, but less than 300,000 in income to the association, obviously you're going to have to keep more detailed records than a community that basically keeps a spreadsheet of in and out with categories that has less than $150,000 in cash receipts and expenditures. So just understand there are different reporting levels. You can vote to change that reporting level every year. There is something that's the legislature's trying to put in place where you would have to vote on that every year. As of right now, you can vote for 2 years going forward, including the current year. Here's the changing the reporting level. The board can vote to increase the reporting level. The members can vote to decrease it. Required disclosures: if you're not doing any reserves and you're not basically saving money for expenses that are going to come up in the future for maintenance and repair of major assets, you need these disclosures in certain financial documents. You need to file certain documents with the government as well. And yes, we're at 3:55, so I am breezing through this. Again, I truly welcome any questions you may have if they don't get answered during the Q&A today, because I know that this is way too much information to possibly go through in 2.5 hours, let alone the 2 that I try to do it in order to avoid you guys having no time for Q&A. So moving on to contracts or bids, you have to have a contract in writing, meaning it can't be a verbal contract if it's not going to be fully performed within a year, or for the purchase or lease of materials or equipment, and if it's a service type of contract. Okay, those all need to be in writing, which is why I say I will not provide any work for any community association without a written retainer signed. And that retainer doesn't necessarily mean you're paying up front. It just means that's what we call our representation agreement. This is part of the reason. I don't want to get the association in trouble. And frankly, I don't want to get myself in trouble by someone thinking we have a representation agreement when we don't, or the terms of that agreement. Certain things that should be in every contract are listed here. We do have a contracts class that I would suggest you take. Bidding: if the aggregate cost of a contract is more than 10% of the total annual budget, including reserves, if you have any, the association must obtain competitive bids. The lowest bid is not the one you have to take. You take the one you think is going to do the best job. That's your fiduciary responsibility. You don't need to get competitive bids if it's an emergency or if they are the only provider in the county. You also don't need competitive bids for professional services. Okay, so employees, contracts for an attorney, accountants, architects, community managers, engineers, and landscape architects. Okay, I see that, many communities will get competitive bids for attorneys and managers, even though they don't need to. My opinion, if you are comfortable with the individual attorney or the law firm or the management firm that you intend to work with, there is absolutely no reason to go out and just check, well, what else is out there? You might do that from a cost perspective, but when you're comparing the cost of a manager, the cost of a professional, the cost of an attorney to another type of professional, attorney, whoever, manager, you can't compare apples to apples just by looking at dollars. Because the bottom line is, I've got 13 years of experience in this particular field. I've been doing nothing but community association law for that long. Our firm's been in practice for 30 years. I've got 21 attorneys behind me. That's not something you can decide upon factoring in just price. And that's not me selling my services or the firm's services. That's me telling you about every vendor. So yes, you can reach out to 3 vendors, see who you're comfortable with, and get quotes from maybe the top 1 or 2. But you don't have to get a quote from every professional. That's simply not required under Florida law. Contract with a manager, if made by competitive bid, can be made for up to 3 years. Just keep that in mind. It doesn't need to be a, well, we're gonna contract with an individual manager for a year and then we'll reevaluate. You can do it that way if the manager's willing to do it, but it can be up to 3 years. I'm going to skip some of this. Communication services is basically bulk internet and cable. The association members have a right to cancel that contract by a majority of voting interest present at the next regular or special meeting of the association, meaning that they only have one chance to terminate. And just like conflict contracts, the contract in that issue, what we're talking about is basically you can terminate without incurring any penalty beyond the reasonable value of the work that was already done. So it's, again, same as a conflict with these bulk contracts. Moving along, use rights suspensions. This is where we get into covenant enforcement. Again, strongly recommend that you take the covenant enforcement class. You need to enforce your covenants. It is your fiduciary responsibility not to, not to ignore the fact that people are violating your covenants. In my opinion, if all you're doing is fining, you are ignoring those violations. You're not doing what you need to do to actually get compliance. You're doing what might have worked in some other community in Central Florida or South Florida that you lived in before because people actually paid the fines. But to me, that's not working. That doesn't work. That doesn't get you compliance unless and until you actually enforce the fines. If you're willing to file a lawsuit to enforce those fines, that's the only time that that should even be considered as your only enforcement mechanism. You need to look at self-help, which is going onto the property and curing the violation. That comes with its own risks and its own concerns. There's a great article that Jeff Rembaum wrote on Rembaum's Roundup regarding this issue, regarding case law that came out just this past year. Basically saying that if you have that right in your governing documents, you have to use it. That's part of the reason that I'm recommending a lot of my communities actually amend that provision out so that you don't have that right except for the things that the board is willing to go onto a property and actually cure. Because I don't want you putting yourself at risk that you're going to lose your injunction lawsuit because you didn't want to go onto someone's property reasonably and potentially tear up a utility line by installing something to screen the trash cans, things of that nature. But you really should be using the standard covenant enforcement process, which is basically sending out notices. Again, this is one of the policies I recommend, sending out notices, pursuing it, going after the owners, trying to get that injunction so that it's a judge telling them they have to stop doing what they're doing or to start doing what they should be doing, not just the association or its attorney. So moving forward, fines, again, I don't like them. Use right suspensions can be useful. That's basically someone either didn't pay their assessments or other monetary obligations for 90 days. In that instance, you can suspend their right to vote unless your governing documents don't allow that right, or you can suspend their right to use certain amenities, meaning your pool, your clubhouse, things of that nature. Nothing that's going to be associated with actually accessing their property or their parking, but generally speaking, the amenities are what you can shut down. That requires a board meeting. You can also do these same things for non-monetary violations. That's going to require basically the equivalent of the fining procedure. So if you want to properly fine or suspend these rights for violations of the covenants that aren't monetary obligations, you provide notice of a board meeting. The board decides to levy the suspension or levy the fine. Then you have 14 days notice, and the fining committee or the violation committee actually holds a hearing where they basically hear evidence and give the owners the information as to, okay, well, here's what you're accused of doing. Here's what we need you to do in order to cure it. What say you? Then the owner gets to make the argument that they don't think they're in violation. That committee makes a decision. If they vote in favor of the fine or the suspension, then the association sends notice and it's the suspension or the fine goes into place. If they vote no, then that suspension or fine is dead in the water. Jeff, did you need to add something before I continue on?
I just wanted to mention that for folks who may need to head out, we're approaching the advertised time. So the evaluation link is in the chat. I'll go over that once Alan is completed and before the Q&A. All right, but the evaluation link is there. After submitting your evaluations, the confirmation screen forms your certificate, and within that yellow boxed shaded area, within that box, is an active link that says click here for the slides. Many of you in the Q&A are asking that. That's why I wanted to interject. You click on that click here within the confirmation screen after you submit the evaluation. That'll open up another tab with these very slides that will include everything that was covered and everything that may not be covered. So with that said, back to you. And again, I'll be back later to go over this once again.
Thanks, Jeff. And I'm going to try and blitz through everything. The good news is the next section is covenant enforceability. That's one that I really recommend every board member in Florida attend our class on this issue. I think it is extremely important that you understand how to properly enforce your covenants. You should have a policy in place. And this is something, I don't care if you're a client or not, give me a call if you want to discuss my thoughts on it. I'll talk to you for 20 minutes for all I care. But I do think this is so important that it's something I hate that I have to skip through it, but because we have a specific class about this issue, I can tell you I strongly recommend that you go through that class. So moving through, we talked about self-help versus injunction, so we already addressed this issue. And this is just an outline of the two cases that came out in 22 and 23. Assessments in foreclosure, this is where I started with the firm in 2010. I think that it's extremely important that you make sure you're doing your collection and not giving people the opportunity to not pay for 2 years before you send a demand and actually send it over to counsel. If you're deferring all that stuff, you're basically guaranteeing that all the other members of your community are covering the cost of this individual who's not paying. And frankly, I don't care whether it's voluntary or not. If they don't have the money and they don't reach out to you to ask for a payment plan, that's on them, and it's not on the board to make the unilateral decision that it's not important to collect that money. Again, this is a fiduciary responsibility issue, and in my opinion, if you are not trying actively to collect every penny that's owed to the association, unless you've unilaterally decided to actually waive those charges, you are not complying with that fiduciary responsibility, because this is money of the association that you're just ignoring as a debt. So that's the general idea. I mentioned the invoice delivery. If you are changing the method you're delivering these notices that will go out regarding assessments, the member actually has to come back and say, yes, I'm okay with you doing it this way. If not, technically the association still has to send these invoices of your annual assessments in the same manner that you were sending it before. So you may have 2 or 3 different manners that you're sending these out. I think it's a terrible idea. I think it wasn't well thought out by the legislature, I think 2 years ago, but this is the status of the law right now. The notice of late assessments, the first notice that's going to go out, it basically says, here's what you owe. If you don't pay it within 30 days, we're moving forward in the collection process. Now we have some information here. I think one of the most important things to mention is you can't charge interest on interest or interest on late fees. You also can't charge late fees at all unless they're in your governing documents. And you can only charge the greater of $25 or 5% of the amount of each installment. So if your assessments are quarterly, you can't charge $25 a month unless your installments are actually up to that 5%. Okay. You can't just say, well, it's $25, so it's $25 a month, unless your assessments are actually monthly. If you charge $25 a month and your assessments are $20 a month or $20 a quarter, you are overcharging for late fees, and that is technically a violation of Florida and federal fair debt laws. That's another class that, again, assessments is one that I think everyone should be required to take as a director so that you understand this. Moving on, there is a 45-day notice that goes out and says, hey, we're going to file a claim of lien. If you don't pay, if they don't pay, you file that claim of lien. And then you send a final pre-suit notice that says, hey, we're going to file our foreclosure action. Foreclosure action is just a lawsuit. The only difference between that and any other lawsuit is you get your judgment, and after that judgment, the judge sets a foreclosure sale date, which is an auction of the property, and basically says, listen, if you don't pay these amounts that are owed before that foreclosure sale takes place, you will no longer be the owner of that property. Okay, it's not that simple, but that's the basics of it. We won't have time to go into safe harbor or sub versus master, but just understand these are things that I do recommend you read through the slides for so that you have at least a basic understanding, which in reality is the majority of what we're trying to accomplish today. I'm not trying to make you an expert. That would be an 8-hour course, which I'd be happy to teach, but I don't think anyone would want to attend. Okay, that is the purpose here is so that you've at least seen this stuff and you know what to go back to your manager or your attorney with if it comes up. There are actions we can take to try and move a lender's case forward so that they limit the amount that they can wipe out when the lender forecloses as to association assessments. Again, this is one of those things I'm happy to talk about, but I just don't have the time here today because we're already at 4:09 and we're supposed to be done by 4:30. Order to show cause is another way of moving a lender's case forward. Rent demand is an important aspect of collection. If an owner is delinquent in the payment of any monetary obligation to the association, you can actually send out a demand notice that the tenant in that property pay the association all rent that hasn't already been paid to the landlord until that monetary obligation has been satisfied. The statute and the form that I prepare explicitly say that they can't be evicted for non-payment if they're paying the association. So I put that right in the letter. And it basically says you need to pay us going forward or we can evict you because you're not paying us. Not that I've seen a community do that, but it tends to work if you're in a community where that property is going to be rented again and you'll get to send that notice out right away as soon as it's re-rented. Tenant obligations and remedies. There aren't many, frankly. We're going to move forward. Don't get into receivership. This is basically where the association is not being operated or maintained by a board of directors, meaning there is no one on the board. You don't want to do this because it's basically done by an attorney who is then going to charge, frankly, absurd costs, basically having your attorney do everything that your manager and your board would have otherwise done. So if you can avoid receivership, do that. Insurance, basically, you have to have enough insurance. Flood insurance is highly recommended. Again, we mentioned the directors and officers liability insurance. You'll also going to want to have property liability insurance, damages insurance, so that if someone sues the association for pretty much anything, an insurance policy will hopefully kick in and cover that claim so that you're only paying your deductible for the association to be defended instead of paying our firm or your law firm to do all of the defense work from start to finish on an hourly rate. We'll skip some of this, make sure that everything is actually covered that you want in that policy. There are changes that are coming up if you're covered by citizens. There are changes coming up this year in the legislature. We just don't have time to go through them in detail, but be aware that there is a bill out there, actually 2 bills out there that are being contemplated regarding citizens. Claims and limitations are another issue that you want to make sure you're aware of. It's 5 years from the date of loss to raise a claim, not 5 years from the date of denial, not 5 years from the date of other remedies. So basically, make sure that if you get a claim denied, you run that by your attorney right away so that they can determine whether that denial was proper or done in bad faith, and you should be suing your insurance carrier for denying it. Transfer and estoppel fees is another one. It's basically a transfer fee is not one that we necessarily want. It's disfavored. Just understand there's potential legislation that we do recommend you get out to your legislators and say this is a bad idea, to say that when an estoppel certificate is requested, that cost gets borne by the association instead of what it is right now, which is the person requesting the estoppel actually pays for it, so that it's actually related. The cost is related to the individual or individuals that are actually benefiting from it. So I can't go into detail. Again, Rembaum's Roundup does a great job of covering this proposed change, but an estoppel certificate's a document that says, here's what's required in order to bring this lot completely into compliance so that you can close your transaction, whether that's a sale of the property or that's a refinance of a mortgage on a property, to make sure that everything is basically starting from square one as of the date of that transaction. So this is a document that gives all that information. So here's what goes into it. It's what's due, what date it was issued. It's going to be good for 35 days or 30 days if it's not mailed out, which usually I see it emailed or faxed. That's good for 30 days. If you find anything wrong in the estoppel certificate, you do have the ability to correct that. You just can't charge for correcting it. Again, you have 10 business days from the request to actually produce the estoppel, or you can't charge a fee for it. This legislation would say you can't charge a fee at all. So what that legislation would do is basically say that the entire membership pays for this estoppel certificate because it's an association expense that the management company and the attorney will charge instead of the person that's requesting it paying for it as part of the closing process. Skipping the content because it's in the slides. I don't need to read it to you. There are certain charges that you can currently charge that they're trying to take away. The important thing right here is that late delivery. If you take more than 10 business days to produce this estoppel certificate to the person that requested it, you cannot charge a fee at all for the estoppel certificate. So just understand, you need to make sure that if the board gets this, that it gets to your manager, gets to your attorney in time to actually fill out the required information. And I've actually had people seen people sue an association because that wasn't provided and they couldn't close because they had to know what was owed to the association or what problems were on the property. So just understand these closing agents are going to request this like 3 days before the sale is supposed to close or the mortgage is supposed to close. That doesn't necessarily mean you got to produce it within that time, but just make sure that you're complying with Florida law. Run it by your manager and your attorney anytime you get one of these. We went through most of this. There is other information that lenders might request, so just be aware that you can charge up to $150 plus reasonable cost of copies and attorney's fees if you're responding, for example, to Fannie Mae, Freddie Mac, other lenders that need kind of a little bit more specifics than what's in the estoppel statute. Most of the time, they're going to provide a form for you to fill out, and your manager is going to fill it out. And the important part also is if an account is in collection or in with an attorney for enforcement, if you're, let's say you're using our collection program, for example, you'll have no idea what's owed for attorney's fees and costs unless you looked at that account on our website to see what's going on. Because under our collection retainer program, we don't charge the attorney's fees or costs that are incurred in collection until the file is closed. So what I'm saying is that manager needs to be aware of these issues, because if you don't know about those fees and costs and you omit them from the estoppel certificate, just understand you're not going to be able to collect them. That is now an association expense, even though it shouldn't have been. Fair Housing Act, we have a class on. I'm going to skip it. And Jeff, just like we did with condo the other day, I'm going to ask you to jump in, or unless Courtney wants to handle the Q&A, however you guys want to handle it. But I'm just going to kind of to float through what we've got left in the slides. I won't close out my slides yet, but I'm going to make sure that there's nothing that we don't already have a class for that I should be at least mentioning in passing. But this service animal, support animal one is definitely a class that's worth attending.
So Courtney, please go through the Q&A. I see you've been answering some of them. And Alan, if it's okay, I'd like to stop the share real quick, and then you can come back because I want to go over the evaluation process for those that may need to skip out and not hang on for the Q&A, even though we want you to. But obviously the Q&A part is not required for credit or certification. So is that cool with you?
Yeah, I mean, all we had left really was recalls and turnover, which frankly, if you attend the election class that we teach,
Yeah.
most of that is covered in that class anyway. And I apologize to everyone that really wanted all of the information today. You'll get those slides once you fill out what Jeff is about to explain. If there are any questions, again, I'm not, you'll excuse the term, but that's no BS. I truly mean, feel free to reach out to me.
Trying to answer everybody's questions. I've answered a lot. If I haven't gotten to your question, it's because I don't feel comfortable answering it. I would like Alan or your association attorney to answer it. If Alan can answer, that's great. If not, association attorney for sure. And just a reminder, I am not a licensed attorney. The only person here that is Alan. So just take my answers with a grain of salt. Some of them are pretty simple. So I feel the ones I've answered, I'm pretty confident that that is all correct. Thank you.
Okay. Thank you. So I'll start with Barbara Robinson. Our declaration is dated 2/28/78, so more than 30 years old. Do we have to go through the revitalization process? We have less than 100 units and our owners don't participate or respond to anything we send other than paying their quarterly dues. How would we get past our voting requirements of less than 10 unit owners vote? By the way, we have townhomes, villas, no clubhouse or swimming pool. So essentially what we're saying is we have a community created in 78. The question then becomes whether the association did anything to preserve the covenants at any time since February of 1978. If the answer is yes, then you may have some time left. If the answer is no, then chances are you do need to go through that revitalization process in order to enforce any of your covenants. That includes the covenant to pay assessments. So what you would be doing is running that by your attorney. And if your attorney doesn't know about MARTA, they're the wrong attorney in this field. But if you don't have an attorney, you're welcome to reach out to me. The first thing I do for every new client of our Orlando office is pull a copy of their governing documents. And that's one of the things that we would determine by looking at your governing documents is whether that preservation was ever done or if you need to go through that revitalization process. Now, if it is something you need to do, then frankly, you can go door to door. I don't have a problem with you literally campaigning to get the votes in order to revitalize the covenants of your community. So bottom line, I understand less than 10 owners are voting and you have less than 100 units. It sounds to me like you have at least a couple people who are involved and interested enough that you might be able to accumulate the required funding to get this done. But frankly, you probably don't know offhand. And part of what attorneys do is answer questions like this as to whether or not that preservation was already done. If the answer is yes, then you might have another preservation coming up in the near future, but you're not going to be, you're not going to have your covenants have expired, which is really what matters here. So if that's something you'd like to work on, feel free to reach out to me directly if you don't already have an attorney that you're working with, or frankly, if you're not comfortable with that attorney looking into this issue. And hopefully that helped, Barbara. Randall Queroff, can the board or committees conduct video-only meetings during non-emergency periods? The answer to that, frankly, is it depends. My suggestion to give an easier answer that any attorney should say, yeah, I tend to agree with that, is if you do it in a way where you have at least one individual in a room with a computer that's visible to everyone in the room, or you have it broadcast on a TV, and you have 99% of the people attending via Zoom, but you have that room in the clubhouse, or you have a room in someone's house that you're making available to everyone else that wants to attend via video, or I'm sorry, attend in person. Technically, you are holding an in-person meeting because the directors are allowed to vote via video or streaming or phone. They're allowed to attend via video, streaming, or phone. And so if you are holding a meeting where you have at least one person sitting in a room that everyone else that wants to attend that meeting in person is able to come to, then it's a hybrid meeting, not a virtual meeting. And you don't even need to get into whether you're doing it the right way because it's not a virtual meeting. You're basically saying we're holding an in-person meeting, but everyone has the right to attend via Zoom if they want, or Microsoft Teams, or whatever program you're using. Now, my suggestion, if you do it that way, is hold it via the webinar function of whatever software you're using. That way you have a lot more control over who gets to speak and when, just like you would in a regular member meeting. So hopefully that answers your question. I know that it doesn't directly answer, but it's a way around having even a potential issue when it comes to how you're holding your meetings. Next one, Stephen Presley. How do we establish rules for the community as far as members wanting to discuss business at meetings? Does that itself require a meeting with notice and a vote by all members, or just the board? I assume the board can create a rule at a special meeting, but that meeting needs to be noticed 48 hours. So that's like 5 questions in one, and I'm going to answer those 5 questions in one. You're going to have a board meeting, provide 48 hours notice to the members, and adopt that written policy governing members' participation at meetings and how and when that happens during that meeting. Once you're done with that meeting, you're going to disperse and send all of the members in your community a copy of that adopted policy. It can be recorded. It doesn't have to be. But my suggestion is if you want everyone before they buy into your community to know what the rules and regulations are, you should have them recorded and spend that additional cost. So hopefully, Stephen, that answers the question. Linda, exactly what is and who can attend and what can be discussed? I have no idea what that means. I apologize, Linda. If you want to send me an email or give me a call after the class.
She wrote executive, and she elaborated further down, an executive meeting. So I guess that's a meeting of of the officers of the board.
So an executive meeting is a non-existent thing. That's
Right.
what. Thank you, Jeff. I didn't see that. An executive meeting is something that members of boards of directors have created to try and get around the requirement to hold a board meeting. It's non-existent. So you either have a board meeting or you don't. An executive meeting usually means that the board or some committee that is not actually an official committee is meeting, should have given notice, but chose not to. So there is no such thing as an executive committee meeting. It's either, or an executive meeting. it's either and a lot of times the way that this is done is to get around having to provide notice in conjunction with a discussion that should be an attorney-client privileged closed legal meeting.
You know what I've seen, and I don't know if this is here's your water sipping break. There you go. I've
Thank
seen associations after being involved with so many as a non-attorney. I do want to disclose that they have executive meetings of portions of the board, and it's the officers and some others that vote on topics as to whether they're going to go to the full board or not for an approval or not. Is that normal? Is that allowed? Is that something that you've heard of?
I mean, if you have less than a quorum of the directors meeting, then I don't think you have a problem because you couldn't have a board meeting. And that is the way some people get around board meetings, is by passing the information around the board. But I don't, I mean, it depends on the context, and I can't give you a straight answer as to whether that's a way around what you're suggesting, Jeff, by basically voting only on what's going to go on the agenda.
I think it's more clear if the term executive committee was used
Right.
versus an executive board, because then it acts like any other a planning committee or an events committee. Now you want to do this, okay, but we need board approval to do it. So we're going to vote that this committee is in favor of bringing in this comedian over that comedian, whatever, send it to the board.
And at that point, by the way, it would be a committee meeting that requires notice and member attendance.
Right.
So I appreciate that addition, Jeff. Could there be bylaws that do require a percentage of resident approval in an HOA for special assessments? That's a quick answer. Yes, there are many of them. I don't think it's a great idea because there are times that you need that special assessment for mandatory work. I'm dealing with one right now that is for repairing a potential sinkhole, and you can't get a member vote, or you have to provide 14 days notice and have the members vote on it, when realistically you must have that money, you must do the work. So that's why I say for special assessments, it's not necessarily the best idea, but yes, there are bylaws that do require a percentage of member approval. And there's nothing that says you can't amend your bylaws as they exist now to include that. Can you amend the declaration while considering filing a lawsuit with an owner? For example, an owner had an RV in their backyard, but the declaration only says no mobile homes and doesn't refer to RVs. You'd have to begin the enforcement process after amending that. The problem that you're going to have is that that restriction wasn't in place when they began parking that RV in the backyard, meaning that they weren't on notice when they started parking it there, that they weren't going to be allowed to do that. Now, they live in an HOA, so they were on notice that amendments could happen. But if they remove that RV from the backyard, chances are there's nothing to enforce anyway. And even if they don't move it, you might have kind of a grandfathering type of issue that someone tries to argue that they're allowed to keep it because that restriction didn't exist until after they had already moved this in.
All right, Alan, let's do it's 4:29 on the East Coast. Let's do two more. And then
Okay.
if your question didn't get answered, please place it, as Alan mentioned, into the evaluation field number 10.
All right. All the actions that are not right, who do we go to correct without going to an attorney that'll cost a lot of money?
I think that was referring to her previously asked question about what happens at an executive meeting. So skip that one.
Yeah, I mean, bottom line, you go to the DBPR, but chances are they're not going to do anything about it either. So if you don't care enough to get on the board and do it right, then chances are you don't do anything about it. Justin Ingram, what's the proper way to hold a board-only meeting to discuss and vote on contractor proposals for work done in the association? That's an open meeting. Sorry, but there's no closed meeting to vote on contractor proposals. It doesn't exist. Status of the estoppel bill, it's not dead yet, is the way that I'll put it. Thanks, Denise.
Since that was a quick one, do one more.
Shouldn't have been an election. I don't know what that means. Can a homeowner as an attorney assume president without a vote? No, they can't assume they're the president without a board vote to actually make them the president. If there was no one on the board, then what would need to happen is that there's a receivership so that someone gets appointed to the board and they can then appoint the director and appoint that person as president. So I think that's all we've got. We're at 4:30. I appreciate everyone that submitted questions and attended today. I apologize if I didn't get to them. We had 6 left open. I know that one of the individuals who submitted several of them is already in touch with me. I welcome her to reach out to me separately. But again, like Jeff mentioned, if I didn't get to you, please feel welcome to put your questions into your survey responses. Unlike a lot of attorneys, I look at every single one of those. If we get questions in, especially the ones that say, please contact me, I reach out to every single person. Can't promise it'll be tomorrow, but within a week or two.
Well, and too, I'll send you the Q&A report as well as the attendance report, so you'll see which ones were answered, which ones weren't. So folks, you don't even have to worry about remembering to put them into the Q&A now that I'm thinking about it. Alan, Courtney, before I go over the evaluation, anything you'd like to say, any parting words? Because I know you both are busy. I'll hang on for another minute after you both leave to go over the evaluation one more time.
All I want to say is thank you so much, Jeff and Alan. Alan, that was great. It was very informative. I like your style. You had some little like jokes and, you know, quips in there that I was like, oh, okay. Like, I like that. Thank you so much. Thank you so much for shouting GRS out. I would also like to say, real quick, there were some questions in the chat that I tried to answer the best of my ability. I think, Alan, you had mentioned that a lot of those topics that you kind of skipped, you'd said that Kaye Rembaum provides webinars just on that specific topic. And also on Kaye Rembaum's website, there's previously recorded webinars that people can always refer back to if they can't wait or they can't make the next one. So definitely check their website out. I'm going to shout you guys out. They have great resources on there. So thank you so much. Again, can't wait till the next one.
Likewise, and thank you so much for having us, Courtney. If anyone needs to reach me, I'm happy to communicate with anyone that's attending today. Again, as@kbrlegal.com is the easiest way to reach me. We really appreciate GRS having us here, and hope to work with you guys as frequently as humanly possible.
Thank you. I forgot to plug my own email. If anybody needs to reach me or GRS or has a question, you can reach me at Buchan. So C is my first name, Buchan, BUCHAN @grsmgt.com. Thank you.